Добрий ранок.
Good morning.
So today we are continuing our interviews with candidates for the position of the disciplinary inspector. And we start from our candidate Evgeny Moisyuk. Welcome to the interview. So first of all, I would like to introduce our commission. I'm Rada Molena, the chair of the commission, and commission members are as follows: Yulia Bokova, Olena Kopi, Olga Popikova, Pavel Zhelinchik, and John Ehrlich. Would you have any requests regarding the composition of the commission?
No, I have no requests regarding the composition of the commission.
When you speak, just turn on the microphone. That's good. So the procedure is as follows. We will have an interview of approximately 1 hour duration, and sometimes we prolong the interview for 10-15 minutes. It depends, but approximately the duration is this. And we will start from your presentation of your motivation, your professional experiences that bring you here. And then we will have a session of questions about your professional competences and personal qualities and your integrity. And at the end of the interview, you will have several minutes for your final comments and remarks. And also I would like to notify you, probably you know that our interview is broadcasted, so if you have any information which falls under restrictions for its public disclosure, please let us know and we will decide accordingly. So if you do not have any requests or questions so far about the procedure or any other, we could start from your presentation. So the floor is yours, please.
Thank you. Good morning, dear members of the Competition Commission. My name is Evgeny Mykolaievich Moisyuk. I'm a candidate for the position of a discipline inspector of the High Council of Justice. Answering to your question regarding my motivation, I would like to mention the following. The High Council of Justice, as a constitutional public authority and authority of judicial self-governance, performs so many important functions, and one of the crucial such functions is definitely performing a disciplinary proceeding. And specifically, the service of disciplinary inspectors, which has been recently established, is aimed at implementation of the High Council of Justice function in order to set a pool of judges with high integrity and high professional competence. So I strive and I have a great wish to become a member of this team, which will contribute to performing by High Council of Justice of such mandate in order to restore authority of the justice. Taking into consideration my age and my professional experience, which is not that huge in comparison with other candidates, for me it's a huge, incredible start, and it's an honor to be a candidate specifically for such a high position and to have a potential opportunity to realize my ambitions, professional development, and improve my skills. I am confident that the service of disciplinary inspectors and generally the High Council of Justice, they shall not create an image for the public, for external observers, for other judges, as an authority which is perceived as punishing authority for judges, and as an authority which covers behavior of judges which lacks integrity for the public, but for the High Council of Justice to be an authority which actually gives claimants some kind of mechanism of impact in order to make a decision. Such it shall not be perceived like this. That's why, as a candidate for the position of a disciplinary inspector, I would contribute to High Council of Justice to make such decisions which will be highly motivated and justified for the above-mentioned judges, the public, and leave no doubt of them, and they will not think that judges lack integrity. And definitely, one of my aspects of my motivation, and I will not lie to you, it's high remuneration, high status of this position. And it's also important that this is a civil service. And it means, as a civil servant, I will keep having some certain guarantees regarding my professional development. I would say the following. I have graduated from the Yaroslav Mudry National Law University. Immediately after graduation, I started working in the private enterprise as a legal advisor. I worked with claims and litigations, and under my functions, I had interaction with public authorities, mainly with law enforcement authorities. I worked on different requests, responses. I drafted claims, lawsuits. I participated in court hearings as a representative of this enterprise. I also interacted with clients of this enterprise to some extent. Then I started working in the Criminal Court of Cassation Supreme Court, and I worked there at the role of the court hearing secretary. That was my start of my civil service. I worked there for 6 months as a secretary, and then I moved to the position of a consultant of the court, and I have been working at this position since that moment. And my duties include so many things. First of all, I work on draft court decisions, and at my experience, I worked on all current types of court decisions which are issued by the Cassation Court. De facto, I'm familiar with all procedural issues related to the Cassation complaint, and participate in the process from the very beginning, of submission of the accusation complaint, through all the stages till the moment of consideration and merits, and till the end, depending on what's the decision of the court. And that's all. Thank you.
We'll proceed to our session of questions and discussions, and I would like to give the floor to Commission Member Yulia Bokova to start this session. Please.
Thank you, dear Reda. Greetings, Yevgeny. I will have a few questions to you regarding your professional competence and general questions regarding your motivation letter. The first question I would like to ask you, in your motivation letter, you mention that the goal of having this position of a disciplinary inspector, that you would like to contribute to the processes related to strengthening trust to judges and to improve situation with compliance of judges with ethical standards. So tell me, please, do you think that there is no trust at all from the public to judges? I think that it's not that it's completely absent, but it's very, very low. Why did you make such a conclusion? I made such conclusion exclusively based on my work and my practice of interacting with courts, also reading some public news, and based on general situation which evolved around judges. Because each day, almost each day, there is a new case where judges discredit themselves and the judiciary system at large. And as such cases become high-profile cases and become publicly known, and I understand that the pool of judges in Ukraine consists of many thousands of judges, but specifically such cases actually bring a shadow to the whole pool of judges, showing such lack of integrity. And earlier, I didn't face, but I saw publicly that some judges were not brought to responsibility, others avoided this responsibility, and in general, the public and I, as a part of the public, of the society, receive this image that the trust is very low. For me, the trust to the judiciary and actually what could be confirmed that the trust is high is, so for me, this is the cases where I participated and where my rights of a participant to the process or as a representative of the enterprise were not violated. But there are not so many of them, because usually I face different kinds of violations. Tell me, please, how specifically you are going to restore trust to the judiciary? What actions are you going to take? Exclusively within my powers, writing relevant proposals and helping the High Council of Justice to perform a disciplinary proceeding, because a disciplinary inspector has range of powers which allows them to withdraw some claims which have no grounds at all, and in order, because those claims actually delay consideration of other cases and bring more and more shadow on judges. So I can express my opinion and my justification in findings if I think that grounds expressed in a disciplinary complaint, if there are any signs of disciplinary offense indeed are present, I will express my motivated opinion in my findings and deliver it to members of the HCJ, who are going to make a decision regarding whether to open a disciplinary proceeding or to deny an opening or to leave it without consideration. So that's how I'm going to do it, by my motivation. Tell me, please, what are the challenges that you see as a position of a disciplinary inspector? Challenges? Yes, challenges. The biggest challenge that I see is that the volume of work. I realize that it's huge. And the second challenge may be some kind of potential impact and attempts, tries, how to impact, to foster opening or denying of opening or leaving without consideration of some disciplinary complaints. And that's all. In your motivation letter, you mentioned separately that challenges are the following. That's lack of legislative acts which shall strengthen work of disciplinary inspectors, lack of motivation to changes and undesire to change the rotten system and the low level of motivation within the team. These are the main challenges. What did you mean saying it? So maybe I related to my personal experience when I submitted a disciplinary complaint, which is still unsolved, I understand what are the motives, and that's why that's the only thing what I meant there. That, yeah, I realize that the service discipline inspectors has been established just last year, I think, and discipline inspectors, if I may so, if I may say so, discipline inspectors have a huge volume of disciplinary complaints, I think several thousands, and that's why I have such an impression that de facto my rights were not restored after submission of a disciplinary complaint. And so that's is the foundation for my justification of this, of formulation of this wording, of the low level of organization of work. But upon my request, the head of the discipline inspector service of the SDI provided a justified response. Everything was explained. I think they were convincing. So yeah, station is like this. Thank you. Indeed. Last year, the service of discipline inspectors has been established, and we have broadcasting of sessions of discipline chambers, and with involvement, with participation of discipline inspectors, which were selected to their positions. So tell me, please, what would you change? What would you make more effective? What ideas you have? Change in terms of what? In terms of legislation? No. You mentioned, including in your motivation letter, the low level of self-organization and rotten system. So tell me, how you are going to contribute to the development of the service of discipline inspectors? You know, maybe, if I may say so, maybe I would extend the team, the number of discipline inspectors, to have more professional people, which will ensure disciplinary proceedings. Maybe some changes, I don't know, maybe shall be made into the rules of procedure, how such disciplinary complaints shall be considered. Maybe some changes shall be made regarding prioritization. Do you have certain specific proposals? No, I don't have specific proposals. And what did you mean saying the prioritization of consideration? As far as I know, the opportunity to prioritize consideration of cases is defined by only one criteria. Maybe I'm mistaken, sorry, but I think that there is only one criteria, that a judge submitted an application on transfer. And this is a criteria which can indeed help to prioritize disciplinary complaints against this judge in comparison with other complaints. I maybe would introduce other criteria, or maybe I would consider all disciplinary complaints according to chronology. Maybe this is a decision mistaken one, but yeah, we need to consider it. Tell me, please, regarding the disciplinary complaints according to which are the prioritized disciplinary complaints according to the rules of procedure. As I have mentioned already, disciplinary complaints which were submitted against a judge who submitted a request to transfer from one court to another court. As far as I remember, these are the complaints that shall be considered first. Thank you. Tell me, please, are you a person prone to conflicts? No. And if there are any disputes in a team of your peers, how are you going to have a solution? Do you mean in a team? Yeah. Disputes in a team of your peers? Yeah. I don't know. De facto, I have never had some huge, hard disputes in my in team of my peers and working team. Yeah, there could be some working moments, working aspects when you need to come to help, to take some papers from them, so on. So I have a wonderful team at my work. And I'm speaking right now about the office of a judge where I'm working right now. So we have a very, friendly team of colleagues. And definitely, generally, I was very surprised because the Criminal Court of Cassation, the policies there, they are so obvious. Everyone are so polite, everyone's so polite, is so nice. I didn't have any conflicts with anyone.
Thank you. Tell me, please, what is the main principle of the High Council of Justice here when it is applied to the use of the disciplinary sanction to judges? Proportionality. A disciplinary inspector, while studying the disciplinary complaint, decides on facts reflected in this disciplinary complaints and which facts may show that some disciplinary offense was committed, and then the inspector decides for oneself for suggestion to the HCJ how to qualify this disciplinary offense. And of course, all of that is determined according to the principle of proportionality between the punishment and the offense. Tell me, please, what powers do inspectors of the HCJ have during the preliminary check of the disciplinary complaint? While receiving a disciplinary complaint, a disciplinary inspector primarily studies it, and in the process of the check, the inspector may adopt several types of procedural decisions. The inspector may leave it without consideration and return it to the complainant based on 3 grounds stipulated by Article 44 of the HCJ. The same article envisions that the inspector may adopt its opinion with a suggestion to leave the disciplinary complaint without the consideration and to submit this opinion for consideration to of the High Council of Justice. The inspector may adopt an opinion with a suggestion on opening of the disciplinary proceeding or denial in opening in view of existence of grounds set out by Article 45. There are 4 grounds for that. Also, a disciplinary inspector, while performing their powers regarding preliminary study of the disciplinary complaint, may determine witnesses, documents that can become the basis for the justification of motivation for adoption of a specific decision. Inspector may send requests to public authorities, courts, may suggest to the judge to provide explanations. Overall, that's it. Thank you. And I have one more question to you. Is participation of the disciplinary inspector mandatory at the meeting of the disciplinary chamber of the HCJ? Participation of the disciplinary inspector is not mandatory during a resolution of the issue on opening of the disciplinary proceeding by the disciplinary chamber in response to the inspector's suggestion. The disciplinary chamber may also decide to deny an opening and to leave the complaint without consideration. The disciplinary chamber may invite the inspector to provide explanations, but participation is not mandatory. During consideration on the merits, yes, mandatory. Thank you. Madam Reda, I'm passing the floor to you.
Now I would like to give the floor to Pavel Shleminchik, please.
Good morning.
Good morning.
I would like to elaborate more on the part of your motivation letter which concerns the aspects of the judicial processes and the judges themselves that the High Council of Justice was created to correct and bring up to high standards of legislation. Can you tell us a bit more? What do you mean by those encounters you had experienced during your previous practice, which made you to put this so high on your motivation letter?
Yes, thank you for your question. While working in a private sector, in the legal sphere, as well as during my personal matters, where I had to protect my rights in courts, almost always encountered the situation with a delay of case consideration, with unwillingness to consider the cases, with unconvincing motivation. For example, if my requests were denied. And in these instances, I used procedures for challenging of decisions, and if impossible, once I had to submit a disciplinary complaint. That's what I've encountered.
Delays, unwillingness to proceed, and unconvincing justification, right? Okay.
Yes.
How will you handle the situation when, with this, having this perspective of judges in Ukraine, when you will deal with a case which will be very similar to what you have experienced, but it will be brought by a very different person against a judge whom you might know or not, but it will be just like your case. What will be your way of thinking when you will see a case, oh, this looks like my case? What will you do?
I would approach consideration of such complaint with maximum impartiality. When I was submitting my disciplinary complaint, I, for myself, due to the circumstances that I was aware for, I was convinced that there was corpus delicti of the disciplinary offense. But in case I, as a disciplinary inspector, receive a similar or a very similar disciplinary complaint, then of course I would proceed exclusively based on those facts that I would see in the disciplinary complaint. Each disciplinary complaint and each case are unique, and it is necessary to proceed based on principles of individualization.
How will you do that? How will you distance from your previous personal experience?
Probably morally only I would distance myself. I do not see, if you are hinting at some self-recusal, I do not see any grounds for self-recusal.
Hinting on self-recusal, I am trying to find out what will be your process of thoughts when you will face the situation. What actually happens? Because I understand the general principle. I will not be touched by my previous experience, but I want to see what will be going on in your head.
I don't know. Probably I would consider this case exclusively in the context of assessing specific circumstances described by the complainant. I would request materials of the proceeding. I would look at possible grounds or obstacles that existed in the court for consideration, which caused the delay. I do not know. Maybe in my case there were some objective circumstances that made the judge delay it.
Thank you very much. My next question is very different. What is your highest personal achievement? What is the thing you are particularly proud of because you have achieved that?
at the beginning of my professional career. Probably it was the first year of my work as a lawyer. My supervisor gave me a task to draft an appeal to the European Court of Human Rights. I drafted it, I prepared a package of documents, and back then it was accepted by the European Court of Human Rights for consideration. I don't know, probably that's my achievement, because while working in the court, I would not single out some moments. In fact, I'm very proud of the fact that I managed to draft decisions in such a justified and reasoned way that they receive their approval both in the court and from the panel of judges. And if it happens like that, that's already a matter of pride for me, that I can express myself and I can motivate decision in such a way that high position judges agree with the position that I prepare.
Thank you. And the fact that you basically started your career, because the entrepreneurship at the beginning, in the early year of your career, was a short period of time, and then you started to work for the Supreme Court, right? The fact that you managed to work there is not considered by you to be an achievement?
The fact that I managed to work the position in the private sector?
No. The Supreme Court, 1 year after you started the practice.
Yes, I believe that it is my achievement. For me, the Supreme Court was something unreachable. I passed the competition and I was selected. Yes, at first as a secretary of court hearing, but my key goal was to implement my potential and use my skills. I really wanted to draft decisions. And as soon as the opportunity was presented to become a consultant of the court where I could use these skills, I did that. I even accepted the maternity leave position. It did not play a role for me because I did want to engage in intellectual activities.
Can you please share with us, from all your knowledge about the Ukrainian disciplinary system and judiciary, can you mention a case which you think it's on the edge? It can be a violation, but it also probably may not be a violation. I am asking now about a concrete case which happened or is going on in Ukraine, and you are aware of such case. It's difficult to say whether it is or it is not a violation, and please do not consider delays. I am more focused on impartiality, independence, and the main principles of the judicial ethics, which you might see as dilemmatic or debatable, whether it is or it is not a violation.
Frankly speaking, just on the go, I cannot recall anything. First of all, I don't even know. Anyway, from those decisions of the High Council of Justice that I looked through when judges were brought to disciplinary responsibility, or when it was denied to bring judges into disciplinary responsibility, out of those that are available at the website of the HCJ, I have never had an impression that they were not reasoned or motivated. So I've never had this conviction that that decision was illegal. Maybe now some disciplinary cases are being considered like that, but unfortunately I do not know about them.
Sometimes even the members of the disciplinary chamber right, dissenting opinions. So even the body itself debates among the members whether it is or it is not a violation, or but if you don't have that information, that's fine. My last question follows up on our yesterday's interview. Did you have a chance to look at the video or listen to the interviews from yesterday, please?
I watched a part of one interview. I come home back late and they are quite long.
Maybe you already heard this question, but I will try to reformulate it a bit and adapt it to your situation. From the file, we see that your family members helped you significantly when you were quite young with regard to arranging the apartment, living, and so on. Suppose, please, one of them comes to you and asks for something related to your work as a disciplinary inspector, even something very, very small. As human beings, we often feel indebted to those close to us and do not want to disappoint them. Can you walk us through your mental proceeding, how you would approach such a situation?
I think that my work would not be the subject matter of some separate discussion outside of my workplace, especially if it concerns some specific aspects. I will not say that, for example, with my parents, I would talk at all, that I have some cases in my proceeding, but it would be nothing more than just nothing more than what is allowed by the law. Even in the court, I do not especially communicate about the cases that I have in the court outside of my work. And I have this principle that has been developed. My father is a judge. That's why during entire lifetime, I have never heard about his work. I have not shared about my work either. And I think that would be the approach that I would use while working as the disciplinary inspector. Microphone.
So I understand that you said this basically will not happen, right?
I'm not saying that I would be completely closed off regarding my work.
My understanding of your response was that this will basically not happen because it didn't happen in the past when your father was judge, so it won't happen now either. But what if did happen? And I'm not talking about your father, I'm talking about other family members as well, will come to you and ask you for something very, very small, and it will happen. What will be your thoughts?
For me, the notion of asking immediately evokes rejection. I would act exclusively within the framework of the law, and there is nothing for me that could lead to some behavior that could display that I can go beyond these measures. And if someone is asking for something, you can ask only following the procedural proceeding. I am categorically against such requests.
Okay. For now, this is all from me, Madam Chair. And that I will pass the floor.
Dobry ranok.
Good morning.
I am going to change a little bit of my questions based on what my colleague has just asked. So I want to give you a very specific example. You indicated your father is a judge. How would you handle a situation where your father came to you and said, I have a very good friend who's also a judge, and he has told me that you are handling his disciplinary action. You are investigating a complaint against him. And I want to let you know that he is a very good judge. He's very dedicated, he's very conscientious, and he's planning on resigning at the end of the year. So this is going to ruin his entire record if he has discipline against him. It would be really nice if we just let him resign in a couple months and have his record available to him, his spotless record of integrity, honesty, accomplishment. This will ruin everything he's worked for in the last 25 years. Now what do you do with that information?
You know, regarding the fact that the judge has integrity and perfect, spotless record, and just a generally good person, it's confirmed by lack of any actions from the side of the judge which could be subject of an element of a disciplinary offense. Maybe in such a case I would provide some a self-recusal. So I will reach out to my direct supervisor asking to give this complaint for consideration of another disciplinary inspector, because the subject of this complaint is acquaintance of my relative. But if in this disciplinary complaint there are elements of a disciplinary offense, this judge should bear disciplinary liability, and that's a fact which helps to restore trust to the judiciary. It's not about the fact for the public, you know, to perceive the HCJ as the one which actually covers judges, independent on the experience, on the record of this judge. No, the record of the judge actually should help to act with integrity, with responsibility, specifically before going on retirement. Such behavior even shall be extended rather than making some violations or giving some additional grounds to bring them to disciplinary liability.
So you've indicated that you may go to your superior and say, I've been advised that this case has been assigned. The judge who's the subject of the case is a friend of a family member. And your supervisor, your superior says, how did you find this out? What are you going to tell him?
I would say as it is from my father.
He says, what did your father tell you?
I think that's what you have mentioned, that's my acquaintance, that he was telling so many good things about him, and he is speaking about a person who is acquaintance, who is a subject in my proceeding and against whom a disciplinary complaint was submitted. Maybe it even doesn't matter, or doesn't significantly matter what he has said. Already the fact that that's an acquaintance, that there is some connection between my father and this judge, even if my father doesn't speak anything good about this judge, but tries to give some negative things about this judge. Anyway, for me, as a disciplinary inspector, it would create some kind of biased perception of this judge. And the relevant motives I would define in my speech to my direct supervisor.
In my hypothetical, do you think your father was trying to influence you?
What did you say? Did he try to impact me? Can you repeat the question, please?
Certainly. In my hypothetical that I just gave, do you think that your father was trying to influence you with respect to taking a certain action with regard to discipline against the judge?
In the hypothetical situation, yes.
Proper. In the hypothetical situation.
Не можна.
No, it's not proper, for sure.
Grounds for disciplinary action. I'm not saying your father would do this, by the way.
Я вважаю, що ні. Він
I think that no, that he is retired, as far as I know.
ніяким чином не взаємодіє.
In any case, in any situation, he has no interaction with his former colleagues. And that's why, yeah, I think now. So he just lives his life. He lives in village. Everything is possible in this life, but you know, the probability, I define this probability as very low.
I have some more questions, but I want to be conscious of the time, so I'll pass the candidate. Thank you.
Enjoy about those situations. I will continue, but from a bit of different perspective. I would like you to ask to recall maybe some situation from your professional career when you had a really sharp debate with the person who is your boss or maybe your colleague, and you have a very strong inner conviction that you are right, and it concerns some very important matters like human rights or some infringement of some rights. And this person tells you, well, probably you could recall some situation with a judge or maybe from your previous career, and tells you like, leave it, because just do it what it is said. You have to prepare like a draft or some document, and do not argue anymore, because it's just not your business. But you have this very strong conviction that, well, it's not fair. It's not fair. So what have you done, or if you haven't had this situation, what would you do in your? How would you behave? And how did you feel in this situation?
Працюючи на посаді консультанта,
Working at the position of consultant of a court, you know,
касаційними скаргами,
I work with cassation appeals, with preliminary consideration of those cassation appeals, and with further alignment with the position of a judge. Yeah, and maybe, not maybe, but yeah, in some cases, I had my own position on the matter, but all my positions, all my beliefs, they actually were left behind after discussions with my judge, because my judge is from academic fields, as a scholar. His knowledge is so incredibly deep in his field of specialization, and when we have some discussions with him on matters which
мав якусь свою позицію чи думку,
in which I had preliminary previous position or standing, he usually provides me with such, you know, convincing justification, legal justification, that all my doubts are just disappearing. And you know, because of my, frankly speaking, not huge experience, I can't have you know, such disputes with a judge and a scholar of such high level, and yeah, all my doubts were eliminated, maybe because of my low level of experience or low period of experience in such disputes and discussions with judges. But I have never had any cases where constitutional rights of any person were violated. So all rights were always fulfilled in all our cases, always. No, there were no such cases.
In your previous stage of career, when you were telling us that you were representing interests of your company in courts, so I guess there were some situations when you kind of lost a case, right? And you felt like, well, in maybe some occasions you felt like, okay, well, but the arguments of the court, the justification, well, it's convincing, so yeah, that's life. But there were probably situations when you felt that no, it's not right, it's not fair, and how did you feel at that time? What was your first thoughts? What should you do? How should you react? And what, because it's very, human that we feel sometimes frustrated and we think, no, I will fight, or okay, let them. So what is your reaction?
В таких випадках
In such cases, I feel so angry.
окреме я це аналізую по
And I feel so, it's so exasperating for me. For generally speaking, if I may if I may call it as internal aggression. Internal aggression raises so strongly in me when some rights are violated. Speaking about my previous career, previous work, all my complaints or notices of claims were either confirmed in courts or not confirmed. And if I didn't agree with a decision, I had available tools for me to challenge it, to submit, a challenge, an appeal, or leave it as it is. Maybe in some cases, there was a need to challenge the first decision. For example, there was a case when
була призначена до розгляду скарга в порядку.
the challenging appeal was submitted for consideration according to Article 303 of the Criminal Procedure Code of Ukraine. It was considered without my participation, and in the decision, investigation judge mentioned that I was informed properly about the timing of consideration of this challenging appeal, but I was not informed. It was done, I don't know how. It was done somehow. Maybe it was just a template decision of an investigating judge. And it was so exasperating for me. It was so outrageous for me. I realized that at that moment I cannot challenge that decision. But anyway, I tried to refer to general foundations of the criminal proceeding, and I managed to challenge. I managed to win in that case, and the appellate court indeed made a decision in my favor, confirming that there was no such information provided to me. So it was reconsidered again. I don't remember the final decision on that case, but anyway, the fact is the following: that at that case, I managed to stand for my right. When my right is being violated, I'm ready to go till the very end, even regarding the case which is related to my to my suit regarding the pension fund. I submitted my complaint to the European Court. It was my complaint was not admitted there, but anyway, the fact is the fact that since the moment of submitting my notice of claim until the very end when the decision in merit is made, during this process, I submitted all applications and complaints to the European Court, to the High Council of Justice. I submitted different motions to the court itself, but they were ignored. So I'm ready to fight for my rights till the very end.
This brings me to the follow-up, maybe short question. So you are referring and emphasizing that for your own rights, you are ready to go till the end. And for someone else violated rights, is this different?
No, it will not be different. it's just you know.
Дисциплінарного інспектора.
It's based on my functions of potential disciplinary inspector. It will not be different for sure. As a civil servant, I act only within legislation and according to the procedure and provisions of the law and the constitution.
More short question. I'm very curious, but I would like to give a floor to you. If we have some 2 minutes, I will ask my question. Please.
Thank you, dear Reda. Greetings, Evgeny. You know, first of all, I would like to say that congratulations that you're here. And secondly, so you know, if you become a disciplinary inspector, you will not get such good, warm conditions provided to you by the High Council of Justice, because disciplinary inspectors do not work in, you know, in a very warm room, so to say. They stand for their positions, for their findings. They're independent in their work, and indeed, in order to be independent, they need to have their own position and need to fight for it, to stand for it, because at the different sessions of our chambers, we sometimes have some quite harsh debates. But that's just for your information. I wanted to ask you the following. To my opinion, your experience specifically in the criminal court is extremely important, because we don't have so many specialists on criminal law and the criminal process, but we have so many different complaints against judges and investigative judges within the criminal proceedings. My question to you: why do you think there is such high number of complaints specifically against investigative judges? Yeah, of course. I know that the position of a disciplinary inspector is an independent position. You will need to somehow justify your findings. And it also gives me an impetus, you know, to act. Regarding complaints against investigative judges, maybe that's because they consider sensitive issues related to violation of human rights. On the pretrial investigation stage, it's related to detention issues, to ensuring right to protection, right to a trial, so many different functions. And that's why so many people who do not agree with such decisions, or, for example,
Обрання розміру застави.
for example, to opt and to decide on a bail amount, and or
Особи, стосовно якої вони приймають,
so it could be different.
організатором для звернення
It could be different, and regarding it, and because and parties to the proceedings could think that their rights are violated if there are no enough grounds to make such decisions. Yeah, you know, just yesterday I asked this question, and I have another question. Maybe that's a little bit discussable. But I don't want to take a lot of time, so I will try to formulate it in such a manner. All the time, it's being underlined that there is low trust to courts, and we shall restore, we shall work. Why is it so? Why such paradoxical situation? We have allegedly so low level of trust, but at the same time, we have such a huge number of cases, complaints, appeals, and so on. And this number only increases each year. You know, self-recusals usually not submitted, and so on. Why do you think it's so? Maybe the level is not that low. No. To my opinion, it depends on the. It indeed depends
взагалі виконання
on the lack of professionalism in terms of implementation of duties by public authorities, by different persons. So, I know that my father faced station in which he needs to fight for his rights in courts, and it was not only a single case. And I noticed it not only once, that all judges who go on retirement, and to my opinion, 100% of such judges who become retired, they are faced with this situation when they need to come into litigation process for the issues of remuneration, for the money paid to them when they are retired. Yeah, and that's the reason of it, that the lack of integrity during implementation of functions by public authorities. And the level of trust is not related here. It's just the only mechanism of restoring the rights. Maybe not the only, but the most crucial mechanism of restoring rights. That's why people go to court and submit their complaints and cases. So do you have this wish? Do you participate in competition? Yes, I had a wish. I participate in the competition. Is it successful for you? You know, at this stage, I'm still in the competition. So right now, it's at the stage of practical assignments. You mean the competition for local courts? So that's a course of first instance. Yes, general specialization. What's the priority for you? Competition here or competition of a judge? Yeah, I understand why you're asking this question, why you're concerned regarding it. I would like to say the following, that as of now, for a disciplinary inspector's position is a priority for me, and it's not just by accident, it's actually justified. First of all, at the previous competition for the position of a disciplinary inspector, where the new inspectors were selected, I would have participated also in that competition if I had reached the age of 30 years. Now I have this opportunity, and I'm participating in this competition, implementing this opportunity in practice. But if I'm in ranking lists for the position of a local court judge, I evaluate it from the perspective of a probability to win a competition for a certain position. I'm not going to speak about timing, how long this competition could take time, take into consideration the previous competition of 2018. Okay, but in a year, you're appointed as a judge. You will leave the job as an inspector and you go to work as a judge. Do we understand it or not? Is it like this? No. I just trying to tell you the following. If I'm included into the ranking lists of judges, for me, only some courts, a few courts are prioritized. For others, I maybe would be only in the reserve list.
Good morning, Yevgeny. I would like to come back to your motivation letter. And I would like for you to explain several sentences of yours. With respect to the key challenges, you've mentioned that the main challenges in the work of a disciplinary inspector potentially include maintaining high standards of professional ethics and competence. So you believe that compliance with the high standards is a challenge? Is it a challenge for you to maintain high ethical norms? No. I understand that that is an undeniable goal and a principle for the performance of duties by disciplinary inspectors, but I might assume that in case there is a huge scope of work, maybe it will be necessary to somehow fight with trying to comply with them. As I've mentioned, my disciplinary complaint has been submitted for several months now, and I have not seen a procedural decision on continuation of terms, and that's what I'm talking about. So you're the author of the disciplinary complaint? Yes. What is this complaint about? Against whom? And as a who? I have the role of the complainant. I have a case considered by the court, I filed a claim against the pension fund of Ukraine with the Kiev Administrative Court. I know that I assume that it's not a secret for you which procedure is used there for consideration of cases. My claim was not registered for about 4 months as an incoming document. Then I don't even know, maybe for about 2 years it was under consideration following the simplified procedure where the term for consideration is 2 months. In response to all of my motions and applications, I received ignoring. So your complaint is about the violation of the terms for the consideration of the case? Yes. Let's imagine the situation. You are disciplinary inspector. You receive such a disciplinary complaint. And the judge mentioned in the complaint is the judge of Kiev District Administrative Court with a workload of 4,500 cases. What are your actions? Undeniably, in order to take a decision whether the actions of the judge contain the corpus delicti of the disciplinary offense, it is necessary to clarify in each particular case all the circumstances of the specific proceeding. And I understand. I've also received the head of the court apparatus. You are the disciplinary inspector. You get this complaint for consideration. What are your further actions? You have received it. What's next? Do you mean actions following the rules of procedure? I don't know whether we will be governed by the ROP. You are the discipline inspector. You are not going to ask me all the time what to do. Or you won't ask your supervisor what to do. You are the disciplinary inspector. You get this case regarding delay of the terms for consideration of the case by a judge of Kiev District Administrative Court with a workload of 4,500 cases. What are your actions? What are you going to do next? What are your conclusions, opinion? What it will be? I think that I would workload. I see that from the complaint. I don't know. Maybe the complainant told you, maybe someone else. I would request explanations from the judge. I would ask about motivation for the delay or failure to consider this complaint. I would probably send a request to the court about the situation with the consideration, number of consideration of cases. That's about the workload, yes? Yes. I'm convinced that it has to be the subject matter of assessment from the perspective of the judge's intent to intentionally delay consideration of the case. Indeed, if I receive the response from the court that the judge has 4,000 cases under consideration, and then I think I would what is the conclusion made by you as the inspector? I would submit an opinion with a suggestion to open a disciplinary proceeding because formally there is a corpus delicti of the disciplinary offense. I'm just convinced that the judge who has 4,000 cases under consideration, it shall not narrow down the rights of the person who has filed the claim because I understand your point. I'm not asking you about that. I am asking procedural questions. You have prepared the opinion on existence of grounds for opening of the disciplinary proceeding. Yes. Your opinion is received by the disciplinary chamber. Let's imagine two situations. The disciplinary chamber supports your opinion and opens the disciplinary proceeding. What are your further actions? And what opinion will you prepare? But you have already established that the workload of the judge is 4,500 cases. Assessment of materials and explanations of the judge and maybe some witnesses belongs to the competence of the High Council of Justice. From my side, I would prepare the opinion on satisfying the disciplinary complaint, a draft opinion. The opinion is prepared on satisfaction of the disciplinary complaint with a suggestion. Which suggestion? To bring judge to disciplinary responsibility. What is the type that you would ask to apply to this particular judge?
В статті
Article 109 of the law on the judiciary and the status of judges sets out grounds for application. Which type? Just tell me which type of the sanction that you would use at the you would suggest to use to the disciplinary chamber.
я думаю,
I think warning, if I remember correctly. Warning. Okay, thank you. That's it. Another possible scenario. Your opinion on opening of the case is received by disciplinary chamber, but disciplinary chamber takes a decision to deny an opening the proceeding. What are you going to do next? A disciplinary inspector has a mechanism to address the plenary composition. The disciplinary inspector prepares reasoned motion, submission, reasoned requirement, yes. What is the deadline that you have for that, to prepare this motivated request? If I'm not mistaken, 5 days. Within 5 days since adoption of the decision by the disciplinary chamber. Thank you.
I would like to give the floor to Yulia to start the questions about some assets declaration or some integrity aspects.
Thank you. Yevhen, I have some questions to you. Please tell me, when did you receive the attorney's license?
я точно не пам'ятаю.
I do not recall specifically. I remember that I received it either in 2019 or 2020, and I suspended it on the same day. Since when have you worked in the Supreme Court?
Орієнтовно
Approximately since 2019 as well. The right to engage in attorney's activities was obtained by me while I was already working in the Supreme Court. That was the reason for its suspension.
діє.
Where did you obtain the attorney's license?
Я отримав
I obtained it in Rivne region. Tell me please, how did you combine work at the position of the secretary in the Supreme Court and internship? And how long? How long did the internship take according to the law? Since when did you have internship? And how did you combine your work in Kyiv at the position of the secretary of the court hearing and internship in Rivne? Yes, I understand your question. Internship lasts for 6 months.
я його ту частину
The part that could be completed with respect to preparation of some procedural documents or study of the case law was prepared by me during free from work time. And when my participation in court hearings was envisioned, I took part as a free listener. I took annual leave at my work, and then I went to Rivne and took part in those hearings. How many hearings did you attend? Not that many. If I'm not mistaken, I think 3. I think 3, yes. Thank you. I have no more questions.
Dear colleagues, do you have no other questions?
Maybe one.
Okay, please.
Can you tell us, I know that you were young at that time, but can you tell us why your family did live in the house of your father's sister for 7 years or so?
Так,
Yes, I can.
мій батько,
My father,
коли перевівся
when he got transferred to the High Administrative Court, before that he used to work in Lviv. He lived there in the provided apartment. And when he got transferred to Kyiv, he started living in a rented apartment. He was renting an apartment.
і коли його
And when his sister
придбала це
bought this house,
вона
she was buying it for her family.
дозволила
She allowed him and us to live there because what was the point of renting apartment at our own expense if it was possible to live free of charge in a relative's house? That's it. I also lived there, and my mom lived there.
Absolutely clear. So she bought it around that time when he was in Kiev, right? Or
Ні.
yeah.
No. He got transferred to Kiev a long time ago. I don't remember specifically when. For a long period of time, he lived together with his family, including me, in a rented apartment. Then he was in the line for receiving service apartment. Then he got this service housing. It became the subject matter of a criminal offense. Then they started. He refused. He got from this housing because he did not receive it as such, after all. And then I don't remember when, in which year, but this house was bought. I think it was long before, long after he started working in Kiev.
Okay.
Так.
Thank
Yes.
Thank you. So, yes, so our interview is coming to the end. So now it's time for your final remarks. If you have some, it's up to you to. The floor is yours.
I would like to express my gratitude to the entire Commission for asking professional questions and for allowing me to show my competence through your questions, for listening to me, for asking lots of interesting questions, and for performing your functions in general. Thank you and goodbye.
Дякую. So our decision will be announced Our decision on winners of the competition will be announced tomorrow morning at 10 a.m. It will be broadcasted, so you will see the results. And thank you for your preparation and being here with us. And of course, good luck to you. Thank you.
Дякую вам.
Thank you. Goodbye.
Добрий ранок.
Good morning. Good morning.
So we are continuing our interviews with candidates for the position of disciplinary inspector. And now we have an interview with Pani Oksana Rovkova. And first of all, Pani Oksana, welcome to the interview. And I would like you to introduce to our commission. So I'm Reda Moliene, the chair of the commission. And the commission members are Yulia Bokova, Olena Kovbi, Olha Popikova, Pavel Zhilinchik, and John Ehrlich. Would you have any requests regarding the composition of the commission, or no requests? No.
No.
Thank you. So the procedure is as follows. The interview will last for 1 hour or maybe 10 minutes more. And first of all, you will introduce yourself and you will tell us about the motivation and your professional experience. And then we will ask some questions about your experiences and capacities, and also about some integrity aspects. And after all this session, you will have some several minutes for your final comments. And as you probably know, the interview is broadcasted. So if you have any information during the interview that falls under restriction for its public disclosure, please let us know, and we will take our decision accordingly. So would you have any questions or? No questions. So now it's time for you to present your motivation and your professional experience and why you are applying for this position. So you have up to 10 minutes for this. Thank you so much. The floor is yours. Please turn on the microphone while speaking. Okay.
Дякую.
Thank you. Hello, dear Competition Commission. My name is Oksana Rovkova. I will start telling you about myself with information about my education. I studied in the Odessa Law Academy National University and specialization of investigation and prosecution office. I have graduated as a Master of Law in 2014, and after graduation I started working in the law firm. I worked in that law firm as a legal advisor for more than 2.5 years. Afterwards, after this law firm position, I have participated in the competition to the NABU. It was the year 2017. To the Odessa territorial office of the NABU, two specialists for working with witnesses and applicants. I have been working there for around 7 years, till 22nd July 2024. Generally speaking, my legal work experience is around 9.5 years. And I also forgot to mention that when I studied, I worked in the legal clinic of the National University of Odessa Law Academy, providing citizens free of charge consultations, helping them to draft some procedural documents, and I had worked there for roughly 2.5 years while still studying at the university. Now I live in Kiev. I have a wish to work at the position of a disciplinary inspector of the service of disciplinary inspectors, and that's why I'm here participating in this competition, and I'm here coming to this interview with you.
Thank you. Now I would like to give the floor to the Commission member John Ehrlich to start our session of questions and discussions with you.
Dobre ranko. Congratulations on making it to this stage of the competition. I'll be asking a few questions this morning, and then it'll be followed up by my colleague commissioners. You gave us a
Could you please turn off the microphone while not speaking and then turn on when you speaking? Like,
Окей, ну натискати, коли я говорю, і не натискати, коли не говорю. Це зрозуміло. А зараз я можу вже навушники одягти.
так.
Now I should put on the headphones just for me to understand the questions. Yes. Please switch off the microphone.
Cool. So I'd like to just follow up to get fill in some information regarding your employment. You told us about the positions that you had taken previously, and you started off in this legal clinic providing advice to people in need, and then were a legal advisor at a private law firm for a couple half years, and then started at NABU in 2017 and left there in July of 2024. What were you doing? Why was there a 3-year period between employment in 2014 and 2017?
Оскільки я була
Since I was on maternity leave. I have a daughter, she's 11 years old, and that period of time was dedicated to her birth and upbringing.
Thank you. And you left NABU in July of 2024. What were the circumstances under which you left your position at NABU?
The circumstances and reasons for resignation did not exist, only my wish, because I worked for over 7 years at that position and I did not see myself after that at that position. The only reason was desire for career growth, and I could not find that at this position. I worked at this position since the first day of the work of Odessa Territorial Division of NABU, and since the very first day I was appointed to the position, we established the division, we continued developing it, and after working there for 7 years, I realized for myself that I could not see myself anymore at that position. And moreover, I wanted to move to Kyiv. And because of that, I decided to resign and to move to Kyiv and to try to find myself here.
Could you please describe for us the work that you did at NABU when you were there?
At the position, I performed lots of tasks related to legal activities because the staff was not that numerous and all legal issues were given to me as well for consideration. What matters? Consideration of application, their processing, then preparation of some procedural documents, requests, preparation of contracts, information and analytical work, representation of the Bureau in administrative court, preparation of explanations to the court, preparation of the legal position, consultation of citizens. These were the key tasks. So all the legal work was given to a very small number of people, and all legal issues, all legal matters were given to me as well.
And it sounds as though that included your going to court sometimes. How often did you go to court?
Maybe not that often I visited the court just like representation of interest, but I provided many explanations to the court. But I also went to court from time to time. Often, we had many challenges regarding failure to enter information into the register of pretrial investigations or within the framework of the criminal proceedings. So I did represent interest at points.
It sounds as though you left NABU in Odessa for the opportunity to move to Kyiv. Have you been looking for work in Kyiv since July of 2024?
I took part in several competitions in the central office of the NABU as well, but I have not found what I would want for now. But I did apply some efforts, yes.
It appears as though you have applied for about 7 different positions, 4 at NABU, 1 as the Deputy Head of Human Resources, 1 as the Head of Open Office of Communications, 2 positions for Senior Detective. You've also applied for a position with SAPO. You've applied for a position of Judge, and you've also applied for this position for Disciplinary Inspector. Those are all very different positions with different qualifications and experience requirements. Can you tell us what your priorities are in seeking employment?
I've applied to the SAPO for the position of the prosecutor as well as the deputy head of the department. I would not say that these are completely different directions as compared to the work of the disciplinary inspector, because the prosecutor is providing supervision in a criminal proceeding and the disciplinary inspector is working in the disciplinary proceeding, so it is somewhat similar. Both oversight and control are present in both positions. That's more or less close. With respect to the fact that I applied to the NABU, there I applied for several positions, but I was not admitted to competitions there. I was admitted only to the competition for the position of the deputy head of the HR department. And I reached the stage of interview. I passed the test and I reached the interview stage, but other candidates were selected as winners there. Basically, that's it regarding competitions.
What motivated you to choose such different positions, and which area of public service do you think is most important to you?
For me, the most important sphere of professional activities is the sphere where there is the function of control or oversight. I see myself in this particular role.
Why?
Because I feel that I will successfully deal with that.
Can you say what specific experience that you have had that makes you most qualified to fulfill the position of disciplinary inspector?
Every experience in its own way. And starting from the legal clinic and the attorneys association and the National Anti-Corruption Bureau of Ukraine, all of the people surrounding me formed myself as a professional specialist, and I'm really grateful for that because I believe that everyone made a contribution to that. So I cannot say that some experience was more or less important. So since the very beginning, everyone contributed to the way how I professionally understand some matters.
Can you tell us how you see the responsibilities of a disciplinary inspector?
Duties of the disciplinary inspector are regulated by the regulation on the disciplinary inspector adopted by the decision of the HCJ. They are clearly stipulated there. The main duty is preliminary check of the disciplinary complaint that is submitted following the procedure determined by the law on the judiciary and the status of judges. Preliminary check, preparation of the opinion on opening the disciplinary case or denial in opening the disciplinary case. It's a submission to the disciplinary chamber of the HCJ, then participation in preparation of materials for the consideration of the case on the merits by the disciplinary chamber, preparation of draft rulings regarding the resolution of the case for the disciplinary chamber. These are the key functions.
Do you see the disciplinary inspector as having an investigatory role?
Do you mean right now or in the future?
Do you see the role of a disciplinary inspector as the service is currently constituted as requiring an investigatory responsibility or role?
If we are saying through legislative terms, investigative role in the CPC is not stipulated as such, the notion of investigative activities. There is a pretrial investigation and the criminal proceeding, if we are using terms from the Criminal Procedure Code. And the investigative role makes me recall the CPC at once. And the notion of investigative activities is not meant and not defined there. What do you mean by investigative activities, investigative role in your question? Can you please explain?
Certainly. Gathering information about the grounds for the complaint against the judge, contacting witnesses, contacting the judge, obtaining the court record, obtaining court documents, that type of investigation.
Yes, I understand what you are talking about. Since, again, the rights of the disciplinary inspector, according to the regulation, include rules, rights, duties as to how the preliminary check is conducted and how the case is prepared for consideration. Of course, that is about requesting materials, about checking databases, registers, collection of testimonies, explanations. If we call it through some one word, one term of how to describe this activity, maybe it can be named investigative activity, but terminologically it is not determined in the regulation or in the code. That is the activity on preparation and preliminary check of the disciplinary complaint, preparation of the case for the consideration. But whether it is investigative or not, there is no definition of this term investigative activity, and to name it investigative or no, I don't know, because there is no such term anywhere. I have not seen it in the regulation or in the CPC or in the law of Ukraine on the HCJ or in the law of Ukraine on the status of judges.
What experience have you had that you think is most relevant to conducting this type of preliminary check, if you will, if we're not going to call it an investigation?
Every experience that I have, starting from the legal clinic and then up to my work in the law firm and then continuing working in the National Anti-Corruption Bureau of Ukraine, all of these experiences are relevant for formation me as a disciplinary inspector, because formation of me as a lawyer happened gradually and stage by stage. I cannot say which particular experience is most relevant in this particular case, because each experience has turned me into the specialist that I am today.
And could you tell us how familiar you think you are with regard to judicial ethics?
I am familiar because the code of judicial ethics, and we also had the code of ethics in the NABU, more or less every structure, every service have more or less the same code. Principles, standards according to which any official has to act. They are not directly drafted for investigator, judge, or civil servant or disciplinary inspector. I mean that these principles are ethical for all people in general. And both the disciplinary inspector and the judge, your question is about judges, they are general for all officials. I am familiar, I know them. I have been maintaining them, and I have the intention to keep maintaining them.
There are some similar principles between the NABU Code of Ethics and the judicial ethics, but do you think that there are any ethics that apply specifically to judges, and what are those ethics, and why do they apply to judges and not to other civil servants?
Of course, those principles that are related to the consideration of the case in the court, because only a judge can consider the case in the court. Those principles that are related to the consideration of the case in the court, because only the judge is authorized to administer justice.
And what are those principles?
Equality of parties, adversariality, even though I would like to say that equality of parties and adversariality and openness are the principles that are also stipulated for some other official. For example, you've mentioned investigative activities. For the investigator, these principles are also applicable. All the officials that are connected to the consideration of any cases, either in court or during the pre-trial investigation or during preparation of some case for consideration, like in this case, which particular principles that are exclusively applicable for a judge? You mean for a judge, right? According to the Code of Judicial Ethics? Well, exclusively. Adversariality, it's obvious. Equality, it's obvious. But that's applicable not only to a judge. Well, reasonable term of consideration, it's also obvious, but that's not only for a judge. That is applicable to any official that is considering something during some period of time. And what do you think? Which principles are applicable only to a judge?
Well, I'm not answering the questions here. If I were, I might cite impartiality, independence, integrity, some other principles that apply.
These are the principles that are applicable to any official, not only to a judge.
I know that we have a limited period of time. I do want to just ask a few questions regarding the motivation letter that you submitted. You stated that you believe you have the personal qualities that fulfill the requirements of a disciplinary inspector. And then in describing those, you said that one of those qualities that you have is stress resistance. Can you say under what circumstances you have faced stress and how you've handled that?
Stress resistance, you know, it's a very general notion. For every person, the definition and notion of stress is different. All of us have our own understanding what stress means, because people somehow respond to some events that are happening to them, around them, with their close persons, etc. So, you know, all events that are happening in our life are bringing some emotions for us, either positive or negative. And if the person has some negative emotions evoked, then the person is relating that to such notion as stress. So something happened that was negative. The person has experienced some event. Then
I'm sorry. I wasn't inquiring about stress to people in general. I was asking specifically when you have faced circumstances of stress and how you have handled that in resisting that stress. Thank you.
I managed to overcome stress depending on the situation. There is no specific example which I can provide to you. But again, to stay in a positive mood, aiming the positive mood. That's first thing. Do not see only negative things in a station, independently of what has happened. Of course, it's clear that we cannot see only positive things in a situation which is generally negative for us. But anyway, being internally calm, have this common sense and believe in bright future. That's maybe what helps.
I know I have a lot of other questions. I do want to give my colleagues an opportunity also, but last question I have is, you stated that one of the main challenges that disciplinaries would face in implementing their powers would be danger. What were you referring to by disciplinary inspectors facing danger, and how would you overcome that?
I'm meaning here that disciplinary inspector even take into account that he or she carries out preliminary review of a disciplinary complaint, but anyway they are already a participant in the disciplinary proceeding, because anyway the proceeding starts from the moment of submission of disciplinary complaint. So any person related to a disciplinary proceeding, and it doesn't matter what's it, maybe disciplinary, criminal proceeding, any other type of proceeding, but any official is always in the risk zone, because subjects of such proceedings, whether disciplinary proceedings, criminal proceedings, or any other proceedings, such subjects of the proceedings could be already in such a condition of, so to say, which is not like their daily condition, daily status when everything is good. But no, they could be in a condition which could provoke them to act somehow negatively. That's what I meant there. I didn't mean some, general societal danger or something like this. No, in no way. I meant the following. When a person performs such duties and functions, this person is, there is when documents are of high importance. So such person shall be subject to protection from the side of the state, because subjects of such proceedings, in our station, subjects of disciplinary proceedings, they are already persons with some with a deviation from normal life, normal behavior. And if such a person has such deviation in their life, they could pose a threat to an official with their behavior.
I don't quite follow. Is the threat coming from the complainant who's filing the complaint, or the threat comes from the judge? And are you aware of any such threats for disciplinary inspectors that have been put in that position?
From subjects of disciplinary proceedings, so not from complainants, but from subjects who are mentioned in this disciplinary proceeding. So not from complainants, from subjects of disciplinary proceedings.
Those subjects would be judges. Are you suggesting that the judges pose a danger? You're saying the judges pose a danger to disciplinary inspectors?
Not in general term, of course, not in general terms. I just make an assumption that there could be some actions from the side of subjects of a disciplinary proceeding, because this person is already lives already a different life which was before the opening of the disciplinary proceeding, and reactions of people could be different. And that's why I say that disciplinary inspectors shall be subject to special protection from possible negative actions from the side of subjects of disciplinary proceedings, regarding whom disciplinary proceedings are being carried out. Possible danger. I do not say for sure, I say possible. Thank you.
Now I would like to give the floor to Yulia Bokova to continue.
Thank you. Greetings, Madam Oksana. Tell us, please, in your motivation letter, you mentioned such formulation as productive communication. So in your motivation letter, you mentioned such wording as productive communication. What do you mean under it? With whom shall be such communication? Productive communication, in such a case, case of carrying out functions by a disciplinary inspector, it's first of all about communication with the complainant and with the subject regarding whom a disciplinary proceeding is carried out. What is productive communication? It's so to say, final result is to achieve a rational conclusion, conclusion which is trustworthy. What do I mean here? Regarding opening of a disciplinary proceeding or a denial to open it. That's what productive communication is. To identify trustworthy data, factual circumstances. That's communication with a complainant and a subject, and with a subject regarding whom a disciplinary proceeding is carried out. That's what I meant there. Can you give us examples from your professional activities regarding effective communication? I can't speak about myself, because you shall not speak about yourself. But effectiveness of each official, of each employee, is reflected in quantitative and qualitative indicators. At my previous place of work, each year I was assessed according to quantitative and qualitative criteria. And looking at reports on my assessment each year, it was an option to look at my results, my performance results. So what are the tasks which each official faces? What are the functions, the area of responsibility of those officials? And I had both quantitative and qualitative criteria, the number of prepared agreements, documents, drafts, the number of interactions with applicants, and so on. So many how many applicants were there, and so on. So at last place of employment, there were several areas, several tracks. So if you can specify your question, I will be able to give you some details. That's why there were several quantitative and qualitative indicators, and that's what productiveness is about. Can we speak about effective communication in a team? Effective communication in a team, in a team of colleagues. And what does it depend from? Who it regulated by? What regulated? Who defines this effectiveness of communication? No. I asked you about effective communication. How effective communication shall be achieved? What's the result of effective communication? And who shall define the effectiveness of this communication in the team of colleagues? So who is the head of the team? Who? Now I'm asking you, what does effective communication mean for you? Again, for someone, it's for the head, effective communication could be something. So if I'm in the team of colleagues, what effective communication means for me or for something else? For you. So I am in the team of colleagues. So, and what effective communication means for me? That's lack of conflict. That's no conflicts. That's mutual understanding. So if we're speaking about the team and related to the team, but from the perspective of the head of the team, maybe it's more about qualitative indicators which shall be taken more into account. But if I am a team member, that's like no conflicts and mutual understanding between all team members. That's all. Tell me, please, to your opinion, how interaction between HCJ and disciplinary inspector shall be built? And generally asking, shall be there any interaction at all or not? how shall it be? It has already been built. It has already been described in the regulation on the service of disciplinary inspectors.
Питання, як я це бачу, чи
Your question is regarding my vision, or maybe regarding gaps which I've seen. No. My question: how do you think how the interaction with the HCJ members shall be built? How we are going to communicate with them? Is it possible? Is no or not?
дивіться, є поняття
Look.
як службової комунікації.
So there is a notion of service, of internal communication when it's needed. When we prepare our opinions, we submit them to the HHA. The clear algorithms have been defined, the clear-cut algorithms for behavior of disciplinary inspector have been defined. What do you mean here under communication or interaction? I can't answer this question. So there is the issue of fulfillment of your official duties. But communication, of course, we can communicate with representatives of a disciplinary chamber. But what communication you are talking about, I'm not really getting your point. Thank you. Greetings, Madam Oksana. I will have two questions to you. Answering the question of Mr. Ehrlich, specifically why you are still unemployed in Kiev and you do not have take any position, you answered that as of now, it doesn't exist what you want. And what do you want? What's your goal? What you would like to achieve at this profession? Partially I answered this question. Actually, when I answered and said that I perceive that the functions of oversight or control are of my interest, are my desirable roles. That's where I'm looking for employment. Do you participate in the competition for the position of a judge? No, I don't. And tell me, please, self-recusal and recusal mechanism or tool for discipline inspector, what is it and how does it work? If there are grounds for self-recusal of a discipline inspector shall submit an application on a self-recusal, or if a complainant sees that there are some grounds to recusal of a discipline inspector, then a complainant shall submit an application to recuse this discipline inspector. And who is going to consider those applications? HCJ. On all stages. On the first stage. The first stage is which?
Я не буду
I'm not going to make things up because, I didn't read completely information on recusals and self-recusals. Thank you. Okay, thank you. There are no other questions. If I may. Greetings, Madam Oksana. I have a next question to you. How do you handle bias in your work while making decisions? And another question. Have you faced bias from other people regarding you? How do you respond to it? Maybe I have faced such situations, but I do not react to it. You cannot prove everything to everyone. If, if a person reacts somehow with prejudice, with bias, then okay, that's their behavior. Yeah, of course I can submit a complaint if there is something to complain about, but it depends also what the situation is about, what the matter is about. If I just see that, from a human being perspective, yeah, I can say something, but I can't teach everyone. And that's my vision again, and maybe it's not biased, maybe I just perceived it like this in those circumstances, in that situation. No, why actually I'm asking you about it, because functions of a disciplinary inspector envisage that they shall act impartially. So what do I mean here? That there is a complaint, there are circumstances, there are facts. Yeah, I've got your point. That's for example. So again, so you have do you have this understanding of impartiality? If you feel some kind of impartiality, so do not be subjective. Do not take someone's side just because, but to take someone's side which is somehow supported. So do not follow your internal beliefs in full scope. So what do I mean here? Either to open a disciplinary proceeding or denying to open it when I'm drafting a proposal to a disciplinary chamber and submit an opinion. So my opinion shall be reasoned with facts and normative documents. So it doesn't matter whether I liked someone or not, a complainant or a subject of complaint. No. There should be no subjective attitude to subjects. I can, again, if I know a judge, then maybe it's highly likely I need to submit a self-recusal. Highly likely or not? Of course I need to submit a self-recusal if it's my friend, comrade, or so on. Yeah, that's ground for self-recusal. But if I don't know a judge or I don't know a complainant, but during the process of taking testimonies from them, explanations from them, or during communication with them, a complaint, I just don't like a complainant. No, it can't be like this. No, there shall be impartiality, equality of treatment both towards the complainant and the subject. So I shall not behave subjectively whether I like them or not. And what about your attitude regarding verification of trustworthiness of information? What do you think? Do you think it's important or not? I think that's crucial, of course. Of course, it's crucial because if information is not trustworthy, then you have no cases. There is no disciplinary proceeding. So, trustworthiness of facts and circumstances is the foundation, is a baseline. My last question to you, if I may, dear colleagues, to ask. So, I want to ask the following: to your opinion, so the elements of a disciplinary offense regarding a judge, is it possible only, could be possible only when a judge acts somehow during working hours and at their role, or there could be a disciplinary offense committed by a judge beyond working hours, working premises? No, it's possible also beyond, because Code of Ethics covers not only working hours and performing of official duties. Of course, it could be also a situation when a judge is not at their working place. Give us some example. For example, violation of a principle, principle of equality, but again, of impartiality. For example, communication after working hours with one of the parties, conflict of interest, and impartiality regarding whom? But again, it's like a following up. If we have two parties to the case, not during performing official duties. Let's take a store example. For example, a judge goes to a store to buy something. Okay, let's modulate or mock up a situation. For example, there a judge responds politely or impolitely to someone, or responds or reacts to situations. For example, he shows his court ID and goes without a line, without a queue. No, you can't do it. How ID document of a judge corresponds or relates to a line and waiting time for a judge? No, maybe. Of course, it's a violation. Of course, because there is a certain list of situations when ID document of a judge showing that he is a judge is needed to provide. For example, to confirm that yes, he's a judge, that he has official duties to perform, not in a store, not in a shop. Where could be such situations? So that's like what could be situations for him to show such ID document of a judge? To confirm his powers. I don't know when it's needed. No. So let's say that we do not show it to the parties to the proceeding. Yeah, of course we do not show it. In the court session, a judge shall not confirm to parties to the proceeding that he or she is a judge. There is no need because the person is in a robe with a sign and so on. So yeah, if he is in the court session, it means that he is already a judge. Did you have your ID documents? Where did you show it? Well, for example, when I arrived to the central apparatus. So in order to show that you are an official, only to show that I'm an official. Oh, for example, during performing some of the functions, for example, when I needed to communicate with a person, when I needed to confirm something during an official procedure, to confirm that yes, I'm involved, I work in this public authority. Okay, thank you.
You mentioned twice already that, yes, you mentioned while talking about the areas of interest, particular in professional field, this control aspect. So what particular situations in your professional career or maybe in life brought you this understanding and feeling that you are good at this particular area, and this is the what you are interested in, the control, and what do you mean by this?
I mean control functions. They consist in the following. There is a person who is performing functions, and there is a person who is checking, for example, for following the disciplinary complaint, the correctness of performance of these duties, compliance with some principles, standards, norms. These are control functions. Someone is performing the duties and someone is checking the correctness of performance of these duties and compliance with the provisions stipulated by a specific regulatory document. For example, in the Code of Judicial Ethics, whether there is a violation or no.
You consider the disciplinary inspector's main role is the control.
The role of the disciplinary inspector more consists in the preparatory function for the disciplinary proceeding within the framework of the disciplinary case. Because the disciplinary inspector is, after all, conducting the preliminary check and is preparing materials for the consideration of the case on the merits. Yes, it's a part. It's a part of that's not control in full. That's only a part of control functions that are delegated to the High Council of Justice, including the service of disciplinary inspectors.
I'm looking at the watch, so I will ask one question. I will give the floor to my colleague. Nowadays, when the life is going so fast and technologies and all areas of life are developing so fast, we are always in a state of self-development and learning. We cannot stop learning all our life, and it's one of the main actually capacities of a successful professional. So I'm very much interested in what areas of legal areas or maybe other areas of life you are mostly focusing in developing yourself and developing your skills, your capacities. What areas are your areas of interest?
I'm really interested in the legal sphere because for many years I have dedicated myself to the legal sphere. I really like it. And I would like to continue exercising my potential in this particular sphere. What else do I like? I do like many spheres. I can prepare graphic materials. For example, I know how to do that. I know how to prepare graphic drawings. I can prepare some ad materials, commercial materials. I know how to that's my hobby. I can, not can, but I'm developing myself in these directions as well. But basically, I like everything new. I'm always very interested in you, and I'm trying to learn something that I do not know yet, and I'm trying to attempt something that I have not learned yet.
So your these hobbies and professional interests, so you are developing them like yourself, having all those, we all have access to all kind of online and other possibilities, and you are doing some courses or trainings particular, or it would be interesting to know.
In this particular case, I'm engaged in self-education. I completed courses and trainings, but that was a bit earlier. I completed those, and after that, it was just the basis, the foundation, and then I found lots of information in the internet. I'm not doing that professionally. I'm doing that for myself, and that's enough. If I find something new, I'm checking it out, how it works, what else can be done, and in this particular program and software, in this app, etc. Where I learned that, I'm saying that right now we have lots of information that you can find. I will not disclose my sources, but from different sources.
Good morning. I will start my question with your motivation letter. At the same time, I will try to probe your stress resistance. So I will put the question this way. Why should we be even considering your application seriously if you put 6 lines of motivation in 3 questions? What I am saying is it's very brief. The first response, why do you want to become a disciplinary inspector, is I believe that my qualification and personal qualities fully meet the requirements. There are too many people who fully meet the requirement. Why should we take seriously your application if the answers are so brief?
And why not seriously? What is the lack of seriousness in this case? I believe that the constructive and concise answer is the main task for the lawyer. Why should I fill in this position? Because I fully comply with the requirements from my professional experience and personal qualities to this position. That's about the essence of answer.
How much do you want this job on the scale from 1 to 10? Compared to, for example, job of a judge or a prosecutor?
10.
Thank you very much. I stopped my probing phase, and now I will ask the substantive questions. So let's follow up on the issue mentioned by John Ehrlich. Let's imagine the rather unique scenario that the subject of the disciplinary proceeding would put pressure on you as inspector, directly or indirectly. How would you react?
I would not react. I will take explanations on the essence of the disciplinary complaint. Any pressure is not allowed. It's possible to pressure the disciplinary inspector, as you said, the prosecutor, and any official. I have already worked in the civil service. I know what civil official is. And influence, pressure, etc. I know about that. And how to respond? Not to respond. And if the pressure reaches the level that it can be punished by the law, then it is necessary to notify the bodies that have to be notified. I do not know which particular pressure, how it is manifested. If it's just like something verbal, not to respond. But if it's something more, then to notify either law enforcement bodies or other bodies.
Yes. Yesterday we had a discussion with one of the candidates that sometimes the pressure can come via family members. That the pressure is not directly addressed on the inspector, but the family members might happen to be facing consequences of your actions or non-actions. How would you react to that if you learn that your family members are exposed to something like that?
It depends on what. Again, if there's some verbal pressure, then relatives and close persons also have to understand that their close person is holding some position. So they should not respond to some provocations, to some verbal reproaches, etc. Close persons also have to understand that their close person is holding a specific position. If it's something more than verbal, then it is necessary again to notify law enforcement bodies.
Would you feel fear in such situation?
I do not know which particular situation you're talking about. If it's something scary, then yes, probably. But if it's not scary, then no.
Thank you very much. My next question is about your awareness and knowledge of the ethics principles, principles of judicial ethics. From your NABU experience or from your general awareness about judiciary and disciplinary process, can you share with us an example of a case where the principle of judicial independence was violated by a judge? You don't need to name the judge, but the type of violation of the principle of independence. I am not asking about impartiality and bias, I am asking about violation of independence. What can you tell us about independence violation?
Violation of independence of the judge consists in the following. For example, there is the law of Ukraine on the judiciary and the status of judges. There are specific stages for the consideration of the case. In the first instance, local courts consider the case, adopt some decision, then it is challenged following the appellate cassation procedure, and then it can be challenged to the Supreme Court to be reviewed. And if, for example, the person with respect to whom the decision was adopted not in favor of this person is submitting previously, there was an article in the Criminal Code as adoption of unlawful decision intentionally. That was Article 375. Now it's decriminalized. And quite often parties to the dispute abused their right. They submitted a notification to the law enforcement bodies against the judge, alleging that the judge adopted the unlawful decision. Why was it criminalized from the criminal code? Because it was considered as an interference with the judicial activities. As soon as the judge adopted some decision, the losing party sent a notification to the law enforcement bodies, and that criminal responsibility existed. So they decriminalized this article, and they said that there is a decision of the cassation court of the Supreme Court, which says that the only procedure of proving of quashing of the decision is only appellate and cassation challenging. It cannot happen that the person is going to the law enforcement body to quash some decision. That's interference with the independence of the judge.
Thank you very much. And similar but different question. Can you mention case or scenario of a disciplinary case, ideally related to judicial ethics principles, but serious enough for being subject of disciplinary case, where you see it like it can be on the edge, it can be violation, maybe it is not, it is hard to say, it is a puzzling case. It is, one person can evaluate it as a serious violation and the other one will find reasons why it is not. Can you think of such scenario or case?
No.
You think that the cases are basically black or white? It is or it is not?
Якщо
If you provide me with an example of the situation, I will tell you whether it's on the line or no, but I cannot make up the scenario on my own.
I don't know if this will be the situation in your view, but let's discuss it. A judge is going to decide a case concerning damage caused by a pharmaceutical product.
Tak.
And his wife used this same product and faced serious health issues, problems. Do you think he should or should not recuse himself from the case?
Ну, я вважаю, що
Well, I believe that,
я, на мою думку,
in my opinion,
краще
it's better to recuse oneself.
на мою
In my opinion, it's better to recuse oneself, to request this self-recusal.
на мою думку.
In my opinion. But in general, even though maybe yes, in general, self-recusal in this situation should also be requested.
Все ж таки,
Yes, after all, that's a wife, you said, right? That's not some friend, acquaintance, that's a close person,
як перша лінія,
like the first line of kinship. Yes, the judge has to recuse himself. Yes, if that's wife, he has to self-recuse. That's not a friend, that's the wife. Yes, after all, I believe that in this case, he should recuse himself.
There would be an evidence that the judge was so upset about the product, about the company, that he wanted to pay, to let the company pay for the harm it caused to his wife. Do you think he could be even disciplinary prosecuted or not for not recusing himself and deciding the case in his mental state as I described? What do you think?
вважаю, що так.
Yes, I believe yes.
It can be.
Я вважаю,
I believe that yes. In this case, we cannot, if he has some remarks, claims regarding this company, then he has to go to court and get the compensation of damages. But if he has some harm caused by the company, he should not use his authorities to get that.
Thank you very much, that's all.
Thank you. So we are proceeding with integrity part, and John, the floor is yours.
Dobre den now. I just have a few questions on some of the answers that you provided to the follow-up to your dossier. This involves some property and some financial issues. The first involves an apartment that you had owned in Odessa. It's a 44 square meter apartment that appears to have previously been owned by your mother and by your mother-in-law. Is that correct?
Yes.
And the information that we have is that in August of 2017, your mother sold half of the interest in the apartment to you for approximately 474,000 grivna. And that same month, your mother-in-law also transferred 50% of the apartment to you. And that same year, you and your annual declaration declared that the apartment was 100% owned by you. Is that accurate?
всі дані, які
All the information declared by me in my declaration is accurate. There we have the situation that at first my mom was the owner of the apartment, as well as my mother-in-law back then. There is such a notion, mother-in-law, right? After divorce, we were dividing property but we did not do that following the judicial procedure. We just concluded the agreement on the division of the married couple's property, and that's why it happened like that. At first, in the declaration, after we decided this issue, after we resolved that the apartment would be owned by me for 100%, then you can see in my declaration after that that in 2017 I was declaring that I owned it, and in 2019 there is a new date of its re-registration. The matter is that in connection with the fact that during divorce, I and my ex-husband did not divide our property through court. We did that in 2019 through concluding the notarized agreement on division of the married couple's property. So that I started owning that apartment fully since 2019 only, because the apartment was bought during marriage and it was considered as our joint property. And if my ex-husband had wanted to get the half of property, he could have filed the court claim to the court, even though I was the nominal owner of the apartment since 2017. But in 2019 we reached an agreement that he would refuse from his part, and that's why we concluded this notarized agreement on division of our property, and that's why you have those two dates, 2017 and 2019.
What was the year of your divorce?
2017.
And did at any time your husband provide you with alimony?
Yes, yeah, he helps.
Is that income, that alimony, reported as income on any of your declarations?
When what I'm meaning here under saying that he helps, that when we divorced, we resolved property issues. There was not only an apartment, there was also a vehicle. So that's what I mentioned in declarations, including cash funds which were left after the marriage. That was first help provided. Then he didn't help financially, but he helped with bringing up a child, because I was working for some period of time. There was some period of time when he was unemployed, and that's why I managed to support our child financially. As of now, I have not submitted a yearly declaration. I have only a declaration. No, this year, yeah, I submitted a declaration on after termination my official work, and that means that I didn't reflect it there because I still had enough money from the previous place, and also I sold an apartment. I indicated that income, and I indicated the income from selling that apartment, and that apartment was actually purchased when we were married, and so that's also part of his money. That's what I'm meaning here.
Was there ever any either court-ordered alimony or agreement with your former husband that he would pay you a certain amount of money over a certain period of time?
No, we have not agreed in such manner. There were no court cases regarding alimony.
You also received some gifts, cash gifts from your parents. In 2022, approximately 290,000 hryvnia. 2024, 500,000 hryvnia. What were the sources for your parents to gift those sums to you?
So 2022, This was given to me to purchase Nissan Juke, and I reflected it as a gift in cash. And 2024, I reflected it also as a gift in cash. The sources of funds, I can't say on behalf of my parents. They just gifted it to me. I said thank you. I can't answer this question. I do not control where they take money from, what is the source of original funds. I can only thank them. They are not civil servants. I don't know. I don't know how to answer to this question. I didn't ask them about it.
In 2017, you reported income of over $1.5 million hryvnia from entrepreneurial activity. What was this activity?
General activities in the legal field. I was registered as a private entrepreneur. I cooperated with a company in terms of provision of legal services. So my QUET code was activities in the legal field.
So was this an income from your client or from the company?
Так.
Okay.
Yes.
So I'm confused. You worked as a legal advisor for Sparta Law from 2012 to 2014. You started at NABU
Це в адвокатському.
in 2017. Where is the employment or work listed for this entrepreneurial activity?
Я не вказувала.
No, I didn't indicate entrepreneurship activity. I indicated only activities as an employed person. I didn't indicate they are my private entrepreneurship activities. Should I have indicated it? I indicated they are only my employments as a hired employee.
And so were you working as a consultant or as what type of services were you providing?
Ні, консультант.
No. As a consultant, I worked in a legal firm, but now I'm speaking about my work as a private entrepreneur. These are different activities. So the activities are the same, but these are two different employment parts.
And my last question is about the land plot in Zhirovac. How did you acquire that?
Ой, не купляли кожному.
I didn't acquire it. No. Each Ukrainian citizen, according to the land code of Ukraine, has a right to receive in free of charge ownership a land plot. And there was a land plot with this designated purpose for individual gardening, and you can get up to 2 hectares. I just submitted an application to the city council. Each Ukrainian citizen has a right and can do it. So I have up to 2 hectares, so it means that I received it within the provisions of the land code of Ukraine. It was free of charge transfer of ownership of land into my ownership.
Yakuyu, my colleagues may have follow-up questions. Thank you.
Якщо можна, пані
If I may, Madam Oksana, tell me please, answering a question of Mr. Ehrlich, when he asked you regarding a break from 2014 to 2017, you told that you were on maternity leave, but you didn't mention at all anything about private entrepreneurship activities, that you were registered as private entrepreneur and that you had a legal income. Yeah, indeed, I was on maternity leave, but I also was a private entrepreneur. What was the age? What was the year? I don't know. That was you. It was 2016, maybe. I can't recall it. So at that period of time, my child was 3 years old. What I meaning here is that, yeah, the first thing that I recalled in my memory that I was on maternity leave. No, I meant that I was not a hired employee, answering a question of John Ehrlich. But when you were asked what's your place of employment? Did you indicate on your place of employment as a hired employee? No, I indicated only my places of employment as a hired employee. I didn't indicate anything regarding my private entrepreneurship activity. Okay, one next question. Regarding litigation from Accent Bank regarding the debt collection. I was not informed. I saw this information in your questions regarding some kind of claim regarding me. Maybe it's not me there, because maybe it's another Oksana Alexandrovna Rovkova. So you don't know anything about it? No, I don't know anything. No, I saw this information in your questions, but I don't know anything. I have a short question. Since 22nd January 2017 till July 2017, you have been registered as a private entrepreneur. Have you managed to earn such significant amount of money for this period of time? Yes, I earned this money for the period when I was registered as private entrepreneurship. So it was only during 5 months. Yes. Was it a single case or several cases? Several cases. I paid all incomes. It was everything officially done, official activities provided by me.
Our interview is coming to the end, so this is the time for your final comments. If you want to do so, please, the floor is yours.
My final word is thank you. Thank you for your questions, for your attention, for finding time to listen to me, and for giving me an opportunity to show myself to you. I will be looking forward to getting your decision. I'm just thankful, and I just don't want to say goodbye.
So thank you. Our decision will be announced tomorrow morning at 10 a.m. So you will have an opportunity to watch and to see the results. So thank you very much for participation in the competition, and good luck. Thank you.
Дякую.
Все, дякую.
Thank you. Thank you.
Добрий день. Good morning. We are continuing our interviews with candidates for the position of the disciplinary inspector, and now we'll have the interview with Ms. Olena Fudor. First of all, welcome, Ms. Olena, to the interview, and I would like to introduce you to our commission. I'm Reda Moliene, the chair of the commission, and commission members are as follows: Yulia Bokova, Olena Kovby, Olha Popikova, Pavel Zelinchik, and John Ehrlich. Would you have any requests regarding the composition of the commission and or members of the commission?
Дякую.
Thank you. Right now, no.
Дякую. The procedure of our interview will be the following. First of all, we will hear from you about your motivation, why are you applying for this position, and your previous experiences that bring you to this competition. And then we will ask some questions about your professional competences, about your experiences, and maybe some discussions, and then some questions, if there are, about integrity aspects. And at the end of the interview, you will have several minutes for your final comments. The interview would last for about 1 hour. As you probably already noticed, sometimes we prolong our interviews with candidates for 10 or 15 minutes, so we will see. And the interview will be broadcasted, so if you have any information which falls under restriction for its public disclosure, usually it might happen in the part of integrity and family ties. If there would be some questions, then please tell us, and we will take a decision accordingly. And if you do not have any questions so far or about the procedure, we could start from your presentation. The floor is yours, please.
Good afternoon, dear ladies and gentlemen. With respect to my personal motivation, that is firstly the moment of security and how I can influence that through my work, through my participation. Section 2324 of the association agreement signed by Ukraine envisions compliance with human rights. And this way, reforming of the judiciary is envisioned. And during the entire period of time when I have worked in the public sector, so I'm not a person from this system, accordingly I have observed these violations, and I want even more to have them restored in the judiciary. And I want for this aspect to be completed by Ukraine as soon as possible, so that we can finally accede to the European Union, and so that our security situation is resolved. So that's probably my motivation. That concerns not only me personally, but that concerns the entire country that has lived in the war situation for 12 years. Another moment is probably that internally I love entering those bodies that are either newly established or where the composition is renewed. Because I think that through my critical thinking, through my experience, and through my different diverse activities, I can contribute something, and I can influence so that the system that is being formed anew is formed in the most human-oriented manner. What do I mean? In the context of the HCJ, my personal experience 10 years ago, there happened a situation that maybe that was a sign from destiny and one of another motivation factors. 10 years ago, when Maidan revolution was happening and we were active participants of the Maidan revolution, then accordingly, in my opinion, judges illegally adopted decisions on dissolution of the protest, on prohibition for us to have a protest. And we know that there were so-called Maidan judges who adopted decisions like that. And accordingly, there were numerous complaints from the Office of the Ombudsman and from representatives of other civil society organizations to the HCJ. And Cherkasy District Court, Judge Babic, Angelika Mykolaievna, maybe I'm mistaken regarding her patronymics, she adopted the decision, of course, not in favor of Maidan protesters. Then, after the Maidan times, we had the period of attestation of the police and patrol police. And it happened that those employees, I was in the attestation commission for all 3 levels, and those employees of the police which were rejected by the attestation commission were reinstated their positions by the same judge. Since we are public activists, we prepare our agenda on our own and our principles of work on our own. And we've seen that this judge suddenly bought a Lexus car, white Lexus, and she was trying to hide it in nearby neighborhoods outside of the court area. And we actually were monitoring in order to find out and to compare the level of income of the judge and her family members. And back then, when all of these documents were submitted to, I don't remember, it doesn't matter to which disciplinary chamber, unfortunately, the disciplinary chamber did not adopt a decision in favor of us, public activists. It adopted the decision that the chamber did not see signs of violations in actions of Judge Babic. 10 years have passed since then. It's obvious that public activists always want to have results of work here and now. 10 years have passed, and in May, the Public Integrity Council took a decision that Ms. Babic wanted to have a career promotion. And the Public Integrity Council took a decision that, based on her moral qualities, she could not hold the position of a higher level. And she could not become a higher category judge and move to the Court of Appeal. And for me, it was a sign that my work, after all, I thought that colleagues and I had worked in vain, but no, that event gave me a huge inspiration that even 10 years later, my work was not wasted. My attempts were not futile, and we achieved at least some small result. But there was another instance regarding that, when our approach to work, I mean my team and I, and that approach showed that people, the one who is inside the system, I mean those judges who became members of the HCJ, they were judges yesterday and colleagues of those judges whom they are judging now. And every person is treating their new job in different ways. Some understand the importance and why they came to the HCJ, and maybe some have some other motivation and just humanely could not reorient themselves. And there was the instance with another Maidan judge. And in my opinion, on the contrary, the HCJ did not want to find out about the details of the situation. And for me, the HCJ as the mechanism was closed. Back then, I thought 10 years ago that the system was not capable to cleanse itself and to make effective steps in order to function as I imagine that as a human being and as a citizen and as a rights advocacy activist. And when the renewal of the staff was happening, and when the structure was created anew, and when those people who, in my opinion, will be more disconnected from the system and who will be more oriented towards somehow preparing materials in a more impartial way, and to remove this emotional component and to rely more on those principles, so that members of the discipline chamber could really correctly assess the submitted materials. And in this context, the second situation that happened in my life strengthened my aspiration, because I found out that judge, Maidan judge, that was the judge Mozgova, and it happened that she was the youngest judge, and she considered all Maidan cases in one of the district courts of Cherkasy region. And accordingly, then the HCJ decided that to some extent she violated the legislation, and basically she is no longer a judge now. But back then, I think that those people who were collecting materials were not right. Why? Because back then I was the chair of the public council under the state district administration, and everything that was happening in our district, these were very active events when people were interested in everything, in absolutely everything. And Maidan cases were sort of a focus of attention, because back then we lived through these events. And accordingly, as the public council under the state district administration, we could not ignore the events that were topical for the society. So we were collecting evidence how it happened that the young judge was adopting decisions like that. And everything happened from, firstly, it was the established fact, and then people made confessions. The president of the court died, unfortunately, and it happened that the trick happened during the distribution of cases. So these cases were submitted in such a way that all the cases would be distributed only to this judge, and there were 6 or 7 judges in the court, but all Maidan cases were distributed to this particular judge. That was the first fact that we recorded. Secondly, attorneys who wanted, who were appointed, did not want to work at all, because it was necessary to go to Cherkasy to collect evidence regarding Maidan in Cherkasy, and attorneys refused to participate in those cases. And we also have materials about that in the investigation of our public council. And then it turned out that even those people's deputies that were going to bail these Maidan protesters could not do that. And on the one hand, I was infuriated by that as a public activist, but on the other hand, as a lawyer, I understood. In this situation, what could a judge do? If the judge had no grounds, everyone had passports for traveling abroad, no one was bailing them out, defense attorneys were not fulfilling their duties properly. And what a judge can do in this situation? Can we always accuse Maidan judges? No, we cannot accuse all of the Maidan judges of that without finding out about the details. And that's why I believe that my experience is very extreme in some respect. It's experience of being involved into all of these events morally gives me the right to form and prepare some materials and to submit them later to people who, additionally,
you could be in short, because we want to have enough time for our questions. So if you could finish in 2-3 sentences, we would appreciate that. Thank you.
I've tried to tell you everything about my feelings, about my soul. I've shared my internal concerns, and I've explained why professionally I'm concerned about this particular aspect, because that is not our experience. That's experience of other countries. Everyone understands that if we do not restore the balance between the branches of power, that if we do not signal to European countries that we can have this balance between the legislative and judiciary branches, which is delegated to judges, then we will not be the civilized society in their eyes.
Thank you. You can put. Thank you for your extensive presentation of your motivation, which was really very specific with some particular facts. And also you told us about your feeling, why are you applying for this role, and you have, in your opinion, qualifications for it. So thank you very much. Now we will proceed to our questions and maybe some discussion. And I would like to give a floor to our Commission member, Pavel Zilinchik, to start this part. Thank you.
Good morning.
Good morning.
I will start with a few questions regarding your career. Can you please tell us briefly, I know that something is mentioned in the profile, CV, but can you give us some bullet points about what kind of cases you were working on when you were cooperating with the NGOs you worked with?
With respect to my main specialization, that is compliance with rights of national and sexual minorities, and my main specialization is Roma minority. Another aspect is documentation of war crimes. My third aspect, third direction rather, is anti-corruption activities. I have been trainer and lecturer in the training center of the State Border Service in Orshanti, and I was the member of the commission of Cherkasy Regional Council regarding assessment of corruption risks and drafting of anti-corruption programs.
My next question. You mentioned a public council in your presentation. Public council. I don't know if I got the translation exactly as you expressed yourself. Is it the same like the Cherkasy Regional Council, or it is a different public council?
No, that is a public council under Zolotonivsky District State Administration. That's like the executive body, and Cherkasy Regional Council is the local self-governance body, and they have a requirement to prepare the anti-corruption program and to create the commission for assessment of corruption risks.
Next question. Please, can you tell us more about the work which you cited as developing an anti-corruption program, action plan for it, and methods for its implementation? Can you elaborate on this?
Звісно,
Yes, of course, because that is the subject matter of which I am proud, because the NACP recognized the anti-corruption program developed by me as the best back then among all local self-governance bodies and the role model even for executive bodies. They sent that response. That was the result of almost individual work of mine, because when I joined the commission, I managed to get there through some barriers. Because the commission itself, that was created out of employees of Cherkasy Regional Council and people's deputies, did not want to have this civil representation. And those public activists that were there were just representing there. But members of Svoboda political party initiated my candidacy and candidacy of my colleagues, because we already had cooperated in the past and they were confident of my expertise in this topic, and that's why I joined that commission. But then it happened that all the work, finally I managed to convince colleagues that I was not their enemy. On the contrary, I tried to help them and to show something that they did not see. And that's why they gradually gave all the work to me. And when I was performing this work, then Cherkasy Regional Council was in top 4 and then in top 3 of the best in this regard. And when I developed this anti-corruption program, being aware of the local context, being aware of the region, because quite often I visited it, so I knew many of the specific peculiar moments that I included into the program and then action plan. And when the chair of the regional council changed,
Got the point. Thank you. I am sorry that I will interrupt you from time to time, but I have more questions.
Okay.
Thank you. My next question is this. I asked candidates before you, many candidates before you, how do they reflect how Ukraine deals with the dark periods of corruption during Maidan protests or other types of judicial corruption? You already wrote a lot. You stated your position towards this in your motivation letter. That's why I jump right into the legal side of my questions, which is, we often discuss where is the border between the right of the judge to issue a decision based on law and his or her own consciousness, and responsibility for that very decision if it violates severely certain principles. So my question will be about responsibility or accountability for judge's decision. What do you think, where it can be okay to punish a judge, either disciplinary or criminally even, for his or her decision? In which case? Under what criteria?
Ви знаєте, тут
You know, here,
внутрішнє розуміння
internal understanding of a judge is based on what is their level of development, the development of their intellect, conscious, and responsibility of their job, what they do. You know, what is going on in the deliberating room is not under my influence at all. But there are so many ongoing cases right now which are covered by media, where the public has some information about those cases related to some political issues, specifically very sensitive cases on war crimes, when our judges adopt decisions, adopt verdicts, let's say it in such a way, to those inhuman beings. You know, I cannot right now formulate it in a legally correct way. To those people who committed those offenses which have signs of a crime and who have violated provisions of international humanitarian law, and how a judge can act in such situation. If according to the law, they can adopt a verdict, give them life imprisonment verdict. But the public will be maybe happy that the perpetrator received such a verdict. But what will be the criteria? Criteria to define responsibility of a judge. To my opinion, the only aspect of diligent work of the judiciary system and diligent work or appropriate work of attorneys, of lawyers. Why is it so? Because when we are speaking about the reforms of the judiciary, it's not always only about the responsibility of a judge. Here, the responsibility shall be of everyone who participates in this system. That's the defense side, so that's the prosecutor side, the speaking about the criminal cases, the defense side, and the system of evidences presented in a court. If here we have quality of work on an appropriate level, quality of work of all the parties, then yes, then I have, such critics regarding this judge, and maybe I would like to punish a judge, if their assessment was wrong or they ignored some things. Then I have a right to present some claims to the judge. But if we see that all the parties did their jobs, their work inappropriately, a judge is also a human being, and then a judge could make a mistake. And if those mistakes are not regular, then we need to look for a reason, of course. But if that's a systematic approach to make such mistakes, then analysis of court decision, analysis of actions of a judge gives us understanding when it becomes just integral part of their life, of the life of a judge. And yes, then I think the discretional powers of a judge to adopt such a decision could be somehow nivellated, corrected, and then we have a right to issue some concerns or claims regarding him and regarding his potential violation of ethics.
I'm not sure I got the whole answer, or I understood well all the points you mentioned. So I will summarize what I got, and I will ask you whether that was correct or whether you have anything to add. Unfortunately, I did not know what you were referring in that first part, but we don't need to repeat that about the tragic or outrageous actions of some people. We don't not want to go there. I got that you mentioned as one of the criteria that the judge violates the principles and obligations related to his work in a systematic level. So there is some pattern. And if it is not just an accident, an error, but a pattern of behavior, then even the decision can be a base for some sanction. So pattern, is there anything else you would consider as a criteria for accountability, responsibility for judge's decision?
Ну, дивіться, тут іще є таке.
Look, here there is also one more aspect that shall be taken into account, and that's about taking into account local traditions. What do I mean here? Let's look at such example. Now we have an ongoing case in the Ruzhinsky court, and the judge repeatedly says, what shall we take from those Roma people? Roma people are the same everywhere, even in Africa. I think that interpretation will be wrong, and I think that it will be interpreted as Roma, but now I'm speaking about not Roma people, but about gypsies. And as a human rights activist, I would say that it's not tolerate to call people gypsies. No, we shall not call them gypsies. We shall call them Roma. But as as an expert on local content, I know that gypsy have never called themselves Roma people. They always call themselves gypsies. And if other people call them like this, yeah, for them it's okay. But and if human rights activists we will submit a complaint that a judge call a person a gypsy. For a human rights activist, it would be something like insulting. And if we ask a Roma person, have you been insulted by a judge? How it was? And he called you a gypsy. No, it was not insulting, but because indeed we are calling each other a gypsy person. So a judge is...
I got the point. So a pattern, then local traditions. Anything else you would consider in deciding whether the decision of a judge may be subject of disciplinary action or not? Is there anything else?
Я думаю, що
I think that professional burnout, and I also think that in So, you know, in local self-governing administrations and generally, we shall work on this aspect, how to restore capacities of a judge, because judges usually have this constant professional development, but it's related to their professional aspect. But we do not take care of the judges as human beings, as individuals. We do not care, we do not look at where they take resources from. So we demand from judges to behave, to act correspondingly, but we don't take care of where they take those resources from. So first we punish them, but we do not invest in them in order to prevent such a situation for them to become lazics.
Pattern, local understanding of local context, burnout, workload, unbearable workload. Anything else you would consider? That's my last question in this part.
As I have already mentioned, maybe that's work of all parties to the process. So, if we have an increased level of work.
Yeah, thank you very much. So my last question will relate to end of your motivation letter, where you mentioned that you would think about changing the operating principles, abandon the system of quantity indicators and replacing them with quality of work led by people. This is a very difficult dilemma, how to balance quality and quantity. Can you elaborate on this more as possibly future disciplinary inspector? What do you mean by this part?
When I read a report of the civic organization, I don't remember what was the period of that report which they covered, 4 months or 6 months, but in that report they showed names of those disciplinary inspectors, their workload, and they provided some quantitative indicators of performance of certain disciplinary inspectors. Some of them had a figure of 15%, another had a performance figure of 70%. So I started, because I always want to have my own understanding. So I read a report. And, there is no... So I don't have this person who wrote this report to answer my questions, but how it was delivered, this report, it didn't satisfy me. So what the information which was reflected there in that report, that's why I started to look at the situation from my perspective. How would I present information in this report to make it more understandable, accessible, and indeed at the same time reflecting information about work of inspectors for a certain period of time. And here I would present information regarding categories of complaints, because one inspector could get 700 routine complaints, which are very similar and the same in nature, and the person an inspector will automatically do it. He will specialize themselves in this specific category of crimes and not lose the quality, because if that's a narrow specialization, the quality and speediness of work of this inspector is good. It's okay. So this inspector shows good performance indicators and how information is provided to the users of this information. But another inspector gets different cases for different nature, and they need more time to study cases, to provide information in correct way, and at the same time it will impact negatively on the quality of this person, because now today they consider a case under Article 130, tomorrow under corruption provisions and so on. So they don't have this narrow specialization. And we can't say, to my opinion, certain the elaborated managerial methods shall be implemented in order to achieve this balance, both of qualitative materials and in quantity also, because we have 14,000 of cases which are still there. Even genius can't handle it.
Thank you very much, and this is all from me for the start. Please proceed with the further question, my colleagues.
Дякую. Добрий день.
Good afternoon. Good afternoon.
You have a very interesting background. Much of it is activism. Much of it strikes me as challenging the system. How do you think you would handle a transition from activist to civil servant? What challenges do you think you'd face?
Thank you for this question. You know, again, you return me back to my internal things, internal issues, because it's also a challenge for me. And partially, I have already mentioned that I'm not a person from the system. And, you know, to develop my own plan, to develop my own strategy and be a leader for the team, that's one experience. But to be in a subordinating position, to be a part of the team, that's absolutely different experience. But what's the essence of it? So when I started my presentation, so maybe I was speaking for so long time, but I didn't mention one more layer of motivation, that I'm fond of introducing some analytical things. And I think that it's actually the essence of any kind of job, because I realize that a reform is not just about, you know, taking things like let's take an analog. Let's take dumplings and shaking them in a bowl. No, it doesn't work. For example, disciplinary inspectors could be different with different backgrounds. They have used to work together. They have the similar mindset. But I'm coming from beyond the system, so I have a different mindset and different approach. And what people think as something, you know, what they get used to, they just don't see it. They ignore it. That's not their blame. That's just what they're used to. In each task, I love to add something in order to improve the system, an internal memo and some recommendation, some proposal, in order to use it further, maybe as a kind of proposal as changes to legislation, so on. Because, you know, we have some normative acts and some laws, some codes, which are a little bit outdated, which do not meet the current requirements of our times. But we live in 21st century, and people need already new updated things. And so only those people are the best ones who are internally, the system, they can raise those problems in order to improve it. And I think that if I am as an external, you know, person beyond the system, which comes into the system, it will be only beneficial for the system if I come and raise those problems and show those problems. Also, you know, speaking about challenges, I'm just used to it, and you know, it's the style and the nature of my character to put challenges in front of me and overcome them.
Referenced, for example, changing the system, looking at outdated legislation. Are you referring specifically to the work of disciplinary inspectors, or just generally speaking?
No. I'm speaking in general terms. For example, I'm not satisfied with the system, the judiciary system which exists right now, because I don't know why, but medical education requires 5 years, the same as legal education, but then internship goes or residentship goes. But why a judge, a person who is responsible for the fate of the country, which is specializing in the constitutional law, in other law, why a person comes to this position, starts working in this position, and that's all. So I I would do several transfers like this. For example, a young judge could handle, first of all, some insignificant cases, and it could be envisaged in provision of legislation. In order for a judge to look, to learn, to become experienced, how actually motivational part.
If I can, I'd like to, because we have a limited amount of time. So, but how would your role as a disciplinary inspector enable you to propose those types of reforms or be involved in those types of reforms? I mean, you're going to be conducting investigations, presenting cases to disciplinary chamber. What specifically do you envision in terms of your involvement in terms of addressing outdated legislation if you're going to have this role as disciplinary inspector?
Look, as a disciplinary inspector, if I'm not mistaken, a disciplinary inspector will be also responsible for drafting reports which will show independence of the system and independent functioning of the authority where they work. And that's why, using this mechanism, we can implement this function and perform those tasks. And then, let's go further. If our society is also open, if we constantly underline on our cooperation with academic field, with the public, there is no obstacle in front of us to have such sessions, to have such hearings, to discuss, to debate. Everyone will complement with their experience. You are international experts. You are sitting here. You help us to reform our system. And it means when, it could be useful. You have already passed it in your systems. You can share your experience. You can draft your opinion. You can forward it to members of parliament to take it into account when they work on different draft laws. So there are different, so many different mechanisms, and which will help to work on legislation and foster reforms of the system. I think that in Ukraine there are quite enough such mechanisms.
Do you think that you could fulfill that role, that goal, in the position of a disciplinary inspector?
Of course. I'm not only the disciplinary inspector. If I become, I'm also a citizen. I can be a member of a civil society organization. That is not prohibited for me. And this, I'm not disclosing the essence of the work, but overall, if I see that it is necessary to enhance the mechanism of through some amendment, no one is preventing me from doing that. On the contrary, I will be even more interested in doing that because I will be inside the system, and I will see that this is driving force is needed for this amendment. And human resources are exhausted, and people will find it better to work after that, maybe. And maybe it will be a perspective, some possible changes which will result in some other improvement. And maybe 5 years will pass, and that we will come to reform your judiciary systems in your countries. I assume that it can also happen.
Це не жарт, я серйозно.
That's not a joke. I'm serious.
And I can assure you that my country could use it right now. I have more questions, but I do want to give the rest of the commission members an opportunity to inquire. Thank you very much, Yakuyo.
I'd like to give a floor to my colleagues. Yes, because we have not a lot of time.
Доброго дня ще раз, пані.
Good afternoon again, Olena. Really interesting discussion. Especially, I find it very memorizing. I share your opinions with respect to the fact that we cannot put labels on judges based on the example of all Maidan judges, that all judges that took part in that are guilty. Because really, all cases, all disciplinary proceedings are very different, and all circumstances are different. And undeniably, I share that these are very sensitive cases, not only for civil activists, but also for citizens of Ukraine and for judges. Thank you for your support. But at the same time, you know, I would like to share with you an interesting study regarding the fact that this year the European Council of Justice Council conducted a survey. And since we are not members, but we are observers, luckily, So we also took part in that. And you know, it was interesting that overall in European countries and Ukraine, the most influential factors impacting independence include that was sort of a threat to independence, included media, I mean posts, publications, etc., as well as disciplinary proceedings, in particular in Ukraine. Judges believe that entails some threat to their independence. I would like to hear your opinion or your attitude towards that, and then I will have some follow-up question. Thank you for this question. I thought about that, but in which context? I agree with this, but right now we are during the period of the reform, and we're in this transitional period. Look, if we're talking about Ukrainian court history, court was entrusted not to those who knew the laws, but those who were morally responsible in the community. And historically, they were entrusted this position. And then we were subject to occupation. We were for 300 years in occupation. And there we had these panels of judges from the Russian commissions. We had Stus, etc., who were punished for nothing. And now we are in the era of the broken society. And now, during this period, to put high moral standards for judges, I'm not sure that it's possible. And during the transitional period, I suggest to have this check and balances system. And I was preparing for this. And it was there that for 5 years the disciplinary inspector is entrusted this position, and I've realized that I will not work for more than 5 years, because I have promised to myself that in these 5 years we will reform the system, and in 5 years I will achieve not to have this punitive system of the service of disciplinary inspectors. Thank you, Madam Olena. That's such a frank answer. And I would like to quickly continue, because I see time that we do not have that much left. But there is a disciplinary case when the case is initiated, disciplinary case is initiated, and the inspector sees a corpus delicti of the disciplinary offense. When the judge is taking self-recusal, motivating it with saying that one of the parties to the case is filing a disciplinary complaint with respect to this judge, to the HCJ. And the judge believes that this is a sort of pressure. Maybe then the judge believes that the judge is not impartial towards this party. Not the parties asking for recusal, but you know, that is regulated, largely speaking, that believing that that the judge has some biases, then the judge can ask for self-recusal. In your opinion, what would you do in this situation, being the disciplinary inspector? Do you see corpus delicti of the disciplinary offense in these self-recusal instances? I'm sorry. And it's also important, cases are not high profile. So we cannot say that the judge is avoiding administration of judges, that the judge doesn't want to consider some case. You know, it happens. There are some cases that are endless, but these are not the cases like that. I would like to tell you the following. Maybe before the start of the full-scale invasion, I would say for sure, yes, they have to do that, but due to the fact that I spent much time in shelters thinking about things, now I would say no, I do not see that. I understand that to break a person, especially at a public position, is very easy. I do not know whether that judge comes home crying to sleep, or maybe this judge that expresses aggression towards close people. I don't want to be additional reason of stress. And I do not believe that this honorable position of administration of judges under the emblem of the state of Ukraine gives me the right to break a person in such a way. No, the person cannot. She cannot do that. She cannot explain that. I encounter that quite often, trust me, because when I am bringing Roma to the court, I know that some people just hate them. Just but I cannot force a judge to consider the case. So it's better for me when the judge is asking for self-recusal, and then it will be the honest position. And I support this honest position. And that's why the disciplinary inspector is not the punitive body. This is the body that has to collect documents under two positions, as I see it. How I would work. There is no point in displaying your position. My position can happen only after the disciplinary chamber discusses it. Maybe I do not see something and they will see something. They have more experience, they know it better, and they can know it better. And if after that I still have my personal opinion unchanged, then I can submit my motivated request and to defend my position when it's principled. But in this way, I don't want to break down people and to take responsibility for that. Thank you for your answer. Good afternoon, Elena. You know, a very interesting interview with you. Thank you so much for your frankness and openness. Ms. Elena, thank you for your civil position as well. I know that you are also involved into the territorial defense. Okay, let's not talk about that now, but I would like to address you now as a judge. First of all, I'm the judge. Based on your speech, I have been listening very attentively to you. So after all, it appears that you have only negative attitude towards judges and judiciary. Won't it be attitude of yours some sort of concern, a barrier? Will you be objective during consideration of the disciplinary case? Because isn't it your desire to get this position exclusively as sort of some revenge? Because you said that you will have the opportunity to punish the judge. No, on the contrary. No, because I have this impression that you are the civil activist and that you are a very active civil activist. Sorry for tautology, but you are having this position. The judiciary is bad, all judges are bad. Or maybe I'm wrong and I've misunderstood you. No, on the contrary, I said that I do not want to. You've said it just no. I'm talking about your speech. Okay, let me express some positive considerations. Emotionally, the most painful things are the most memorable. Okay, let's put it that way. According to recent statistics, 1.5% of complaints challenges under the military law are 1.5% that is successful challenging. I have 100% of successful challenges of such cases related to the war, and all judges satisfy the position. And moreover, the decisions that are adopted, they are closed. And for me, that is a sign that the work that I'm doing it in a quality manner. And that gives me the understanding that those judges who read the materials are absolutely supporting the legal position, even if, I don't know, there is this system of instructions, barriers, etc. I do not believe in that. I believe that a person is doing what they can. And I'm emphasizing. Maybe you've just, maybe I was very emotional and maybe I was talking very quickly, but I'm always saying that for me, responsibility in the judicial process is put on three parties: prosecution party, defense party, and judge. And preparation of the parties and quality of the preparation of the parties is a decisive factor of the quality of the judge. And I understand that the judge has to be above that, and I have higher requirements to the judge morally as a citizen, but all three parties are responsible for the process. That has been my strong conviction since the very first day when I entered the court hearing and when I was an intern with other attorneys, and I was just observing how sometimes defense attorneys treat their work, and I just realized that humanely the judge is in such a situation that the judge wants to help the person, but the materials do not allow the judge to do that. Thank you for your answer. So can you guarantee that you will be objective during consideration of disciplinary cases? I can guarantee that I will prepare high quality documents due to my experience and due to my capacities. In order to explain the situation as clearly as possible to members of the disciplinary commission. but objectivity, sometimes it's not obvious at this particular moment. Someone you can see who was right only sometime later. Thank you. And now I have a question about your motivation later. I have many questions, but we didn't have enough time, so I will have several. Inspectors are also obliged to ensure that judges with low reputation will not be able to retire in order to avoid responsibility. What did you mean? I mean the aspect of priority cases, when it is clearly stated which cases have to be prioritized. As far as I remember, when a judge is going to retire or when is requesting to retire, then you have to apply all maximum efforts, and even if it is extra working hours. But if you see that according to the prioritization you have to quickly process the case, so you have to do that regardless of the labor codes and to work extra hours in order to make sure that you comply with the terms, so that this judge does not avoid responsibility if necessary. That's a very interesting interpretation of this statement. And tell me please, again, in your motivation letter you said, with respect to challenges, incorrectly or ineffectively organized system of disciplinary investigations. What did you mean? That's about the current service? No, that's what I've mentioned about the system when I read the report. And this quantitative position, that focus was more made on quantity. And I had an impression that maybe it's again the system. Quickly, give result. You have to process all this within thousands. Maybe I'm wrong, but in my impression. But back then I perceived that information like that. Unwillingness to destroy a rotten system and low level of self-organization within the team. Do you mean the service of discipline inspectors? That is the case when I started telling about this Judge Mozgova. It's still in my mind when they did not see the facts, when they did not find out the situation. We are not specialists, right? We just paid more attention and we've clarified what was the claim against Judge Mozgova, even though it started with our impression that we thought that the distribution algorithm is a very democratic algorithm, but here it was used not in favor of the judge. And in this regard, I think that this system, I don't know why that disciplinary chamber did not clarify the situation. I did not see those documents. I don't know why. And I do not have the opportunity now to get in touch with this former judge. But back then, when we were questioning those people who were affiliated, they were regretting it because they said that she was a very professional judge and that she was compliant with all the principles. Okay, thank you. So you are ready to join this rotten system now? I'm ready to destroy the system from inside, and that's a slightly different thing. Thank you. It's necessary to come and see. Not everything is that bad. When I was in the attestation commission in the police, when I was observing the police, I thought that such a sustainable mechanism. When I entered the system and saw it from inside, I understood that there was no system at all. Thank you. And last question. Establishing cooperation with the public sector and academic circles to submit amendments to the committees of the Verkhovna Rada and the Cabinet of Ministers. Do you have this function, this option? As a citizen, yes, for sure. But your motivation letter is for the position of the disciplinary inspector. Yes, but the disciplinary inspector is still a citizen. They are forming a new body. And any external expert opinions have to be taken into account. How can I get them? I don't know. You are the disciplinary inspector. How can you get that? And what do you mean by the notion of cooperation with the public sector? At the position of the disciplinary inspector, not as a citizen, but as a disciplinary inspector. Disciplinary inspector is involved into the preparation of reports on results of activities, and that report on the results of activities of the body will be published. And accordingly, through this tool, we can form the analytical reports, comments, suggestions, and if that finds
громадські організації зрозуміють,
that is found by some NGOs, they will understand their needs, then they can support the topic with their expertise. Thank you. And my last question is the procedural. The Institute of Recusal, Self-Recusal for Disciplinary Inspectors. What can you say about that now? If there are some complaints against the recusal, self-recusal of the disciplinary inspector. If you receive a disciplinary case, you've received it, and you see that there are grounds for your self-recusal, what will you do? Look, if there is a conflict of interest, you see the conflict of interest, you've already reached this opinion that you have to recuse yourself. Who will consider it? It will be at the stage of the receipt of the case. It will be considered by the head of the service or deputy head of the service. You don't remember that, right? But what if that's already in the disciplinary chamber? Then the chamber will consider that. Thank you.
Greetings, Madam Elena. I have also so many questions, but I'm not limited in time. I'm limited in time, so I have a short question to you. Shall any violation lead to disciplinary liability for a judge? What can impact on application of a disciplinary sanction against a judge or non-application? Look, as far as I looked into the practice of how actually it's done, sometimes a chamber chamber has one position, and the disciplinary inspector has another position. But and a chamber could actually make a decision on a sanction which could be very different. So were such cases when a chamber applied sanctions in cases which are not covered by the law? No, not like this. But I mean the following: one that's related to corruption activities or while offenses with signs of corruption actions. I think that in such situation, a chamber shall not be limited only with a warning as a sanction. I think that this category of cases shall lead to a more realistic punishment. But the chamber adopts such decisions. I don't know why. All of us, we say that we have zero tolerance to corruption and that there shall be presumption of innocence regarding such alleged perpetrators. But as a citizen, I do not agree completely with this position. No, I'm not asking you as a citizen. No, I'm asking you. So, for example, let's imagine that you are a disciplinary inspector now, and I have a clear question to you. Is it true that for any offense a judge could be brought to disciplinary responsibility or not? For example, in a situation a judge has very high workload, 4,500 or 5,000 of cases under their consideration. As a disciplinary inspector, what are you going to do? Okay, let's take this example. For example, there is a complaint. Intolerant behavior. A judge insulted or called names of another person. So what do? We shall collect information from open sources. Other users say that this judge is the most tolerant, most balanced in their behavior. I don't see that there is any systematic manner of this judge. So I could assume that this is some kind of a nervous break breakdown or something like this when the judge crossed that line. Or I can assume that there could be a different situation when some subjects of the proceeding provoke the judge in order to lead to such, to such behavior. And then they used this tool of complaint mechanism to submit a complaint to HCJ and then blackmail a judge. So even if they say in their complaints that he violated Bangalore principles, the code of judicial ethics, and so on. Okay, thank you. Next question. Well, how are you going to verify accuracy of information, trustworthiness of information? So as evidences of the case, how are you going to review them? No, you received a case. And in a case, you received a complaint. In a complaint, some circumstances are described. How you are going to review, to verify trustworthiness and accuracy of it? Audio, video, questioning. How are you going to ask questions? I can suggest, I can invite a judge to provide explanations. I can invite a complainant to provide explanations, or I can suggest other parties to the proceeding to provide explanations. Proceeding which is explained in this complaint. And what are the sources of evidences which you are going to use? Legal ones which are allowed. Good, thank you.
Any other questions? Yes, please.
Now we will proceed with some questions regarding the part of your application which concerns the financial integrity. And my question relates to two issues which we would like to clarify. One concerns possible entrepreneurial activity, and the second one concerns unpaid entrepreneurial activity which we collected during the process of preparation. The first one, in the open sources there is an information that the person with the same surname, first name and patrimony is involved and was registered as an individual entrepreneur, manufacturer of road products, bags, leather, other materials, 2024. Does this information relate to you in any way or not, please?
It's not a full list, the full name of code line. So we have the consultations and so many other QUET codes which I have been registered at. Yes, I am an active current private entrepreneur.
And in that case, did you declare the income from this activity, or you didn't in your application?
The issue is that my declaration for 2024 and what you have mentioned, so I didn't have any paid activities for my private entrepreneurship activities for the year 2024. And in the year 2025, yes, indeed, I will declare in my declaration income received from this private entrepreneurship activity.
The second question, in section 15, you also declared that you are engaged in unpaid entrepreneurial activity, which is in some way a contradictory statement, because entrepreneurship usually is aimed at earning money. So what do you mean by unpaid entrepreneurial activity, please?
Це так звані послуги.
These are so-called pro bono services. Usually this category applied to advocates, but to attorneys. But as a lawyer, sometimes I provide some services to Roma people. Not always it's done on the voluntarily basis within my organization. That's why sometimes I do such social activities and provide pro bono consultations.
From me, thank you.
Madam Olena, tell us, please, and explain regarding enforcement proceeding on collection of debts in favor of the pension fund. What is it? So at that moment, I worked at several jobs, and according to current legislation at that moment, so one employer paid taxes and another didn't pay, because I didn't have such employment there. And then I faced this requirement to pay those fees. And as legislation was on my side, I tried to defend myself, but I failed. And then there was a court decision, and I needed to pay, not me, not I was the one to pay, but the employer. And I took this responsibility, this duty on myself, trying to defend myself, but I didn't succeed in convincing the court. So you were officially employed, and your employer didn't pay fees for your employment. I worked at several jobs. No, it's clear. And I also, at the same time, was a private entrepreneur. So is it a debt collection from you as a private entrepreneur? So it was you who didn't pay. No, I didn't need to pay because I didn't have any income at all. Because at that moment, I worked as an hired employee at other legal firms, at other legal entities. But then why the pension fund actually claimed that you shall pay this sum? Because I was a private entrepreneur, FOP, so they raised claims that I didn't pay. I provide them with all evidences that all income that I got, I didn't get as a private entrepreneur. No, I've got that income only as a hired employee. And as a hired employee, the employer should have paid all the taxes with. Okay, one more question regarding the case where you were the respondent on usage of property. What this case is about? Why did you present such obstacles to use the property? There were no obstacles put from my side, but it's related to the following situation. I was living in the house where my father was living too. When my father died, my mom started the inheritance process, and she inherited it, and she sold this property. I was still registered there. When the selling process was done, so the notary made a mistake and didn't notice that I was still registered there. So I didn't live there at that moment. They failed to get in touch either with me or my mom, because my mom also didn't live there anymore. She changed her contact details, she lived in another settlement, and in such a way they just submitted a suit to a court, and it was related to specifically changing of place of registration. So it was done based on court decision. So they deregistered me from that address. It was Cherkasy region, the Lotonosha settlement. Please do not tell us for us the full address, because we are broadcasting right now.
That's it from us in this interview. So now the floor is yours for very short final remark, if you would like to do so.
First of all, I would like to say thank you to the Commission members who represent those states which are not so politically aiming at our country, at my country, but anyway, by their own will, they come here, they come to our country in order to help us to become better and to join the united family of civilized countries. I would like to say thank you specifically to your country, because all the time, historically, your country has been supporting us, and that's why I understand why you're here, why you contribute with your efforts, with your time into this process. I would like to say thank you to our judges all the time when they say that the level of responsibility of judges is the highest, but at the same time they work under such conditions when
багато із них би
maybe many of them would leave their jobs, but they nevertheless they do not leave their work. They keep working. I have already expressed my words of gratitude to Madam Elena for her active civic position. It resonates with my position. That's why her position is so valuable to me. And thank you to you for your support. That you have mentioned that you resonate with my position as a civic activist, as a when you communicate with a person from a system, from within a system, and they resonate with your personal position, it inspires a lot. I would like to thank you to a colleague that despite of certain obstacles, despite of certain obstacles, we have women in the system and they show some good results.
Much for your participation in this competition, for your preparation, for your extensive considerations, very open considerations, and for sharing your concerns, your insights. And the results of the competition, our decision will be announced tomorrow, 10 a.m. in the morning. So you will have an opportunity to watch online and to see what the winners of this competition. So thank you once again and good luck.
Дякую.
Дякую.
Thank you.
Добрий день. Good afternoon. So, in today's afternoon, we have the interview with one of the candidates for the position of the disciplinary inspectors, Ms. Olga Yaresh. And first of all, welcome, Ms. Olga, to the interview. And I would like to introduce our commission. I'm Reda Moliene, the chair of the commission. And commission members are as follows: Yulia Bokova, Olena Kovby, Olga Popikova, Pavel Zhilinchik, and John Ehrlich. Would you have any requests with regard to the composition of the commission?
No, none. Thank you.
So we will have an interview of approximately 1 hour. Usually it is extended a bit by 10 or 15 minutes. I hope you don't mind. And we will give you a floor to present your motivation and what brings you here and to apply for this position. Also, we will ask some questions about your professional experience, your insights about the role of inspectors, and also maybe some questions regarding financial assets and integrity. And at the end of the interview, you will have several minutes for your final comments. The interview is broadcasted, probably you know, so if there is any information considered or discussed which falls under restriction for its public disclosure, please let us know and we will take a decision accordingly. So if you do not have any questions so far or requests, so please proceed with your presentation.
Thank you so much. Good afternoon, dear members of the Commission. Thank you for the opportunity to present myself. I'm Olga Yaresh. First of all, I would like to say that this is the first competition in my life that is so serious. So preparation for each stage has been very thorough, and the awaiting of the results has always been very nervous. So a few words about myself. I was born and raised in Lviv. I studied in Lviv National...
Sorry, just a small break for...
Wait, let me try it again. Okay.
Slower that our interpreters would... Okay.
So, I was born and raised in the city of Lviv. I studied in Lviv National University of Ivan Franko. I'm the Master of Law. After graduation from the university, I started working in Halitsky District Court of Lviv at the position of the court clerk. But in fact, I was performing duties and functions of the secretary of court hearings. So I was preparing materials of the case for consideration, I was summoning parties to the proceeding, I was recording court hearings, and I was preparing minutes and journals. Besides, as a court clerk, several times I also prepared protocols on administrative offense and on bringing persons to responsibility for disrespect to court. 2 years after that, I was appointed to the position of the judge's assistant. I was dreaming about that position. I was drafting draft court decisions. I was preparing case materials for the judge. I was providing organizational support of the judge's activities. In 2018, I went on maternity leave. My son was born. Can you hear me now? John, can you hear me? Can you hear me now? Yeah, that's fine, thank you. So, and in 2020, our family moved to Kyiv. After the end of my maternity leave and after move to Kyiv, I started working in Kyiv in the biggest hydrological power company in Ukraine. I used to work at different positions within these 2 years. Right now, I work at the position of the contracts manager, but during my entire activity and employment in this company, I have been dealing with projects financed by international financial organizations. Like the World Bank, European Bank for Reconstruction and Development, and other financial institutions. I believe that my experience obtained in the court and experience obtained at this job with international projects in the sphere of renewables in the energy sector may be useful during my work at the position of the disciplinary inspector. Overall, I would like to point out that I have selected my job through my heart calling, and I feel the need to go back to my profession and to deal with jurisprudence in particular. My motivation to take part in this competition is that I see the role of the disciplinary inspector as a sort of a filter between the civil society and the judiciary, and in ensuring the balance between proper consideration of cases and appeals from citizens and compliance with independence of judges lies this huge value at this position. Having worked in the court for 14 years, I know how difficult this job is, and what a huge responsibility is put by the society on judges regarding transparency and responsibility. I would like to join the service of disciplinary inspectors and to help with strengthening trust in the justice system. Thank you so much, and I'm ready to answer your questions.
Thank you very much. You already responded to my initial question about how in your career you switched from the public service and working in court to private sector, but you answered this part, though you want to switch again and to return to this profession. So during this now work in Ukrhydroenergo, you already told us that you were responsible also for management of the projects, etc. But with regard to legal activities or legal field of work, what kind of tasks and functions have you fulfilled?
Thank you for your question. Yes, indeed, there are functions that are related to the legal sphere because within the framework of implementation of this project, a large number of contracts is concluded, for example, with consultants, with suppliers of equipment, and I'm directly responsible for the drafting of these contracts. So both as a lawyer and as a project manager, I'm checking the contract, the offer of the participant in terms of its compliance with the requirements. So yes, I have partially used my legal knowledge during these 2 years while preparing documents.
As I understand, though, the date of the resigning from the court was October 2023. You were not, in fact, working for some time already, like 2 years or so, when you were in Kiev, right? So it's like now probably around 5 years outside the court from the judiciary.
Thank you for the question as well. No, the matter is that when the war started in February of 2022, we came back to Lviv because it was dangerous here. We have a small child. He was not even 2 years old. And while being in Lviv, I decided that I needed to go back to my profession, to go back to work, since it was possible to put my child into the kindergarten. I went back to the court and I worked there for a year. And only then, in 2023, I came back to Kiev, and immediately I got employed. I have no gap in my labor experience. You can see that from the copy of my labor book. It is very important for me to implement myself as a professional, not only as a wife and as a mother, even though the mother's role is also very important. That's both the caretaker and crisis manager and psychologist and logistics specialist. So I believe even these 4 years in the maternity leave have brought me new skills, but job and profession are extremely important for me.
Me more about the role of being a mother. And yes, so my question would be, what major changes have you observed being outside now, as I understand, 2 years from the court? You probably are following what is happening in a public space. Also, probably you have some contacts with your former colleagues and you are discussing. So what major changes, positive changes, or maybe shortcomings that are still there, would you encounter as crucial for a judicial system to become a safeguard, a strong safeguard of the rule of law?
Thank you for your question. Yes, I follow up all the updates and news very carefully, and for me it's so important. I think that's a positive thing that the competition was announced in December last year for positions of judges in local courts. There are so many candidates, among which I have so many different acquaintances, and I was also looking forward so much to this competition because I think that courts need new forces, need new judges. That's a positive thing. That's a positive impact of it because this competition is an open, and fair one. I would think that also it would be positive if authority of the justice is supported through increasing of a level of legal awareness of citizens. I'm meaning about the following. A lot of is said about distrust to judges, but I think it's not so high because, as you know, there were some polls where people were asked, and those people who actually somehow reached out to courts, and what's their experience, they were asked. And their level of trust to courts of such people is high. So I think we need to raise awareness of the public and to create a positive, real image of judges in Ukraine.
I found very interesting your observation about your understanding of the role of the disciplinary inspector, that it is a balance between the public expectations and safeguarding the judicial independence. Could you explain more and elaborate a little on this concept? Because it's very interesting indeed.
Yes, yeah, indeed. I think, and I have mentioned before, judge's job is so responsible, so complicated. I know it inside out because I have been working for 14 years in court. All my direct supervisors, they're good, they're transparent, they're honest judges. They were indeed true mentors for me. And I have professionally grown and developed in a very professional field among very good mentors. I think that the Constitution envisages the independence of the judiciary as a guarantee for activities, as a guarantee for administering justice, and at the same time, our citizens have a right to submit their applications and complaints to the High Council of Justice as a disciplinary proceeding authority, to submit their complaints in order for the HCJ to consider possible grounds for violation of their rights. So I think that this very balance of fulfillment of fundamental rights and freedoms, which is presented on right to file a suit to a court and to submit such complaints, and independence of judges, is actually is the key thing of a High Council of Justice and disciplinary inspectors.
Thank you. You mentioned your very, as I understand, positive experience working in the court and having people who are really an authority to you and you respect them. But having this quite a long professional experience, 15 years probably, there were some situations in your professional career when you experienced really difficult situations as a professional and or as a person. Could you please tell us about the most, the most memorable, maybe difficult situation, and how you dealt with it and how you felt in this?
Answering your question, I would like to mention that I was thinking how to answer such a question. And when I was thinking on that matter, reflecting, I was recalling in my memory only situations when a court was under pressure. For example, protests in front of the court. I understand your question, but I didn't have such experience of such blatant facts of violations, or maybe not blatant, maybe just facts of violations. So unfortunately, no, I don't recall, or maybe not unfortunately.
Person, I would say, and that's good. But then in your motivation letter, I found that you indicated as among your personal qualities that are important and also would allow to be a good disciplinary inspector: stress resistance and confidence. So these are qualities that are related to dealing with difficult situations, with difficulties in professional career. How would you be sure that you have these qualities without having these situations in the past? That is my consideration.
Дякую.
Thank you. Answering your question, I would like to say the following, that when I mentioned stress resistance, I meant the following, that I know how to work and I'm capable to work with a huge number of cases, communicate with so many different people, because a local court is a school of life for a legal professional. Each case in the local court is about the life of a person, and staff of court interacts with such person, sees how the final decision of court could impact on their lives. So I can organize myself, I can do huge amount of work, I can handle the pressure from the side of attorneys, for example, who perform their professional duties. Yeah, that's like this.
Thank you. And then I will probably ask one more question, and then we'll give the floor to my colleagues. Coming back to your previous answer to my question about this role of the inspector, keeping the balance between the public expectations and judicial independence, and you emphasized that this is about safeguarding or ensuring those the rights of people who apply with their complaints about the judicial ethics and possible misconduct, and also keeping from the other side this guarantee of judicial independence. What other aspects of or ways to get this understanding of public expectations, apart from just having those complaints from particular people who are participating in court proceedings? What kind of possible interactions or relationships could be between the service of disciplinary inspectors and public or civil society organizations, whatever? Would you see any other possible interaction?
I see those interactions in such a case in the following manner, that the practice shall be generalized, and it's already done by the High Council of Justice. So to generalize practice of the proceedings. So it's very well envisioned in the law on the judiciary status of judges, and on the law on HCJ, rules of procedure of CJ, regulation on the functioning of the service of disciplinary inspectors. So the whole procedure of consideration of disciplinary complaints is very well defined in detail. And yes, such generalization of practice, which is already done by HCJ, already allows to increase actually this forecastability for the society. So what is taken into account when the decision is made? What is taken into account when it's decided not to bring a judge to liability? So I think that that's an opportunity.
Follow-up small question, sorry, colleagues. So, in your opinion, what kind of judicial misconduct or violation of judicial ethics, what kind of these disciplinary cases, so to say, make the most important impact on public trust in courts or distrust in courts? Which offenses or violations, in your opinion, are really the most impactful?
I think that the most impactful is unethical misbehavior, even in personal life. For example, if a judge being drunk commits some kind of an offense, it impacts so significantly on the image of a judge, or when there is no correspondence between lifestyle and income. So it could also impact on the image perceived by society. So many complaints are related to violation of the deadlines and period and for consideration, but I think our judges have so significant workload. For example, a judge with whom I worked in Lviv has a workload of 2,000 cases per year, so with a standard workload which should be much less. That's my opinion.
Now I would like to give a floor to Julia. Julia, please.
Вітаю вас.
Greetings, Madam Olga. I have a short question as a follow-up question to Madam Reda's question regarding pressure. So you mentioned that the only examples, and there was some protests in front of the premises of the court. Maybe you were indeed so stricken out with it. But let's imagine you have a case in your consideration, a high-profile one, or maybe not. But there is pressure there. Maybe some publications in mass media, maybe some other things. So many different posts from CSOs, a protest in front of the premises of the SDI, publications in Telegram channels, and where there are some descriptions, not only from the professional perspective, but maybe even in terms of interventions in your personal life, how you are going to act. Thank you for your question. I think that I am going to act according to current legislation and provisions envisaged in relevant secondary legislations, such as the regulation, the rules of procedure of the HCJ, and the regulation on functioning of the SDI. Within the framework of current legislation, I'm sure that I will overcome such pressure. But what about societal attention, where actually CSOs will raise the issue of that the decision which is made, which is adopted, is unfair? How are we going to act? I think in such situation, I will reach out to my supervisor with a request to go out and express information or publish information on official source, maybe a website of HCJ or website of SDI, covering some facts, why it's happening so, what is the reasoning behind this decision. So to inform the society, it will help to decrease the pressure. Thank you. So do you think that this communication with the society will help to decrease it? And is it so important to carry out such communication in work of discipline inspectors? Generally, I think that yes. I'm so happy to see such openness, which right now exists in the judiciary. It's related to everything, to competitions, activities of the HTJ. That all information is published on the website. It simplifies so much everything for those persons who are somehow related to activities of courts, of the HTJ, and generally, yes, I think that it can help to decrease societal tensions. It will help if we explain some reason, some grounding, so on. Thank you. Greetings, Madam Olga. I have a following question to you. You have already mentioned, and as I can see based on your documents, that now you participate and quite successfully participate in competition for the position of a court of the first instance. No, thank you for your question, but no, yeah, indeed. When the competition was announced, I applied for the participation in the competition for the position of a judge, but there was a bad joke played with me, and it was played by my love to prepare in advance. So I prepared a document of absence of convictions much earlier than it was needed. So this certificate was not prepared in time, much before, and I was not admitted to participation. Oh, it's sad, but what if next year there will be a new competition for the local courts? Are you going to participate? No. For me, this position of a discipline inspector is so important, so crucial. I think that it's a very good opportunity to grow, to develop, to contribute to the development of justice. It's just so valuable experience. So I'm ready to work 5 years at this position of discipline inspector, even maybe longer if I will manage. So we are trying to understand whether you would like to be a judge. You know, a position of a judge, for me, it's the topest position of all other positions in the jurisprudence. Indeed, that's the topest, that's the highest, that's the cone of everything. So I think that young people who were 25 years old, maybe for them it's too early to become a judge, but it's just according to my understanding. So I have huge respect to judges, and of course, sometimes, maybe in future, I would like to become a judge. But now, for me, indeed, a disciplinary inspector position is a priority. Please, let's go further. Disciplinary proceedings regarding against judges are done in chronological order with consideration of which prioritization. So what's this prioritization is about? So first, files of complaints submitted by HQCJ shall be considered, which regarding those judges which could be dismissed based on Article 126 of the Constitution. Also, cases regarding judges who submitted an application to transfer to another court. This is also the priority case to be considered, and maybe that's all. So maybe also dismissal. Yeah. And high-profile cases. Yes. So dismissal and complaints regarding high-profile cases. Thank you. No, I have no other questions. Greetings. Maybe I have some questions. You know, maybe my questions are quite typical because I ask them, almost everyone I ask those questions. Tell me, please, publicity and openness of the process of disciplinary proceedings against judges. Because, you know, it's quite a debatable question. What do you think? Whether it harms or not the authority of the justice? To your opinion, I mean, the fact that such disciplinary proceedings against judges are done in an open manner and online. Thank you for your question. Indeed, it's a very interesting and very discussable question, because I have already several thoughts in my head. Please share them with us. Yeah, of course. So from one perspective, as I have already mentioned, it's very positive that the judiciary system became so open and everyone can have access at any time to consideration of the disciplinary chamber of complaints against judges, to listen to reasoning of members of the disciplinary chamber while adopting this or that decision. But from another perspective, maybe from just, speaking purely from a moral perspective, from a perspective of a judge who is the subject of this complaint. So, because that's also about the authority of the justice. It's a very debatable question, very deep question. I am not ready to give you only one answer. And what do you think? Why is it so that our legislators defined that the disciplinary proceedings against judges in Ukraine shall be open? Because, if I'm not mistaken, and dear colleagues, please correct me if I'm wrong, I think that there is no such experience in other countries. What do you think? Why is it so? Why is it so specifically exists in Ukraine? I can only, make some assumptions. Maybe that's for the civil society to have an opportunity to follow up, to control, to have access to information and to how actually the consideration of disciplinary proceedings takes place. Maybe. Good. Let's go back to the issue. Okay, let's not speak out the figures, the statistical data, but indeed, the number of complaints against judges is so high, and major part of these complaints we are called them as spam complaints. So we have professional complainants who are, it looks like that we even have families of such complainants who submit those complaints. But indeed, we have so many complaints. And again, that's a debatable question. Why, to your opinion, what do you think? Shall we have some certain filters of submission of complaints?
Yes, thank you. By the way, today I read an article on this topic that there should be established a fee for sending an appeals or complaints to the HCJ as the highest disciplinary bodies for if the person is submitting lots of complaints without grounds. Yes, so probably yes, because in fact this problem is familiar for employees of local and district courts, where we also have our own complainants who are coming to the court as if they work there. So yes, I fully understand what you are talking about, but at the same time we are talking about the fact that each person has a right to submit an appeal or complaint. But given that even withdrawal of the disciplinary complaint is not a ground for closure of the disciplinary proceeding. So, these are public relationships that the person is notifying, and even if the person is withdrawing this complaint, if the signal has been accepted, then the disciplinary proceeding is ongoing. That's a controversial issue, because I know that there are many different ideas. Everyone understands that there should be some filters, but at the same time, the issue of payment of the cost is very controversial. And lastly, also to let my colleagues ask questions to you. You are interested in the work of the Service of Disciplinary Inspectors. Are you following it? Are you watching? I'm watching meetings from time to time of the Service of Disciplinary Inspectors. I'm really curious to see how the service works, how the disciplinary inspector is interacting with the disciplinary chamber. Maybe, in your opinion, of the person who has experience in the judiciary, we cannot say that you're just an ordinary citizen who is interested. In your opinion, what you see, what you read, what you hear, what problematic issues exist in the work of the service? Because service has been established not so long ago, but for a year already. Yes, indeed, the service has been working for a year now. I think that I can answer this question while working as the disciplinary inspector, because when I'm watching sessions and in meetings, I like that disciplinary inspectors are proving their positions, provide their evidence, provide justification for their position, that they are independent in collecting evidence, that they always have their personal opinion that they are ready to defend. I really like that in their interaction with the HCJ. And with respect to some suggestions on how to improve that, so far I do not have them. So you will not make anything up, but if you work there, then you will see. Thank you for your answer.
Добрий день. I'd like to follow up, if I may, with your opening comment about the service being a filter between the civil society and safeguarding judicial independence. How do you see the role of the disciplinary inspector applying that filter?
I see the role of the disciplinary inspector in this context in studying in detail materials of each case, comprehensively getting all possible evidence in order not to miss possible violation of human rights that is protected by the Constitution, and in order to prevent at the same time violation of the guarantees of the judge's independence. So I think that during a comprehensive, complete study of each complaint, it will be possible to maintain this balance between independence of judges and compliance with human rights.
So when does it weigh in favor of independence, and when does it weigh in favor of human rights, which inferring means that the judge should be subject to disciplinary action? How does that get weighed? What weighs it one way or the other?
I believe that this way probably primarily consequences of the judge's action, whether it has resulted in some severe violation of human rights that cannot be restored.
You may have anticipated my next question, but in the practical exam, the judge denied the wife and her son the right to see the father who was incarcerated. And you said that the judge had violated legal norms by refusing to grant the permission for the visits, and that he was subject to discipline. The discipline should be imposed against him. And my question is, when is something just legal error that should not be subject to discipline, and when is something legal error which should? In other words, judges make mistakes all the time. I was a judge for 20 years. I made mistakes, and I had a court of appeals to remind me of that. So sometimes when a judge makes a mistake, the answer is to appeal and get that mistake reversed and corrected. And sometimes it could go to appeal, but it might also be subject to discipline. When should a judge's error be subject to discipline?
I believe that the judge's error has to be intentional. The judge's error has from the materials of the case, it has to be obvious that the judge clearly violated the requirements of the law. If the issue is not clearly regulated by law, in our case study, we had this permission for visits. That issue is not regulated by the procedural code, only on the law and the pretrial detention. So in this regard, the judge might get lost, if I can say. Because the procedural law does not stipulate clear boundaries for actions of the judge in this situation. But if the current legislation clearly envisions the algorithm of the judge's actions, causes, results, and the judge is aware of that and still takes a decision that contradicts that, I believe that then it is intentional violation of the law. That's firstly. And secondly, as I have mentioned, yes, consequences to which these actions have led. If the Court of Appeal or if the Cassation Court can correct the situation and the rights will be restored, then that's one matter. But if the rights cannot be restored, then it is a serious consequence that entails the responsibility of the judge, I believe.
Can an appellate court restore those rights and the judge still be responsible and accountable for judicial discipline?
If we are talking about the situation with the permission for a visit, then of course no, because the time has passed. These actions were committed in the past. The Court of Appeal is already considering the case while taking its decision. And the procedural and the interim decisions and the final decision. So in this particular case, I believe that in our case study, it was also stated that the judge behaved incorrectly with respect to the defendant's wife. And while providing my response to this case study, I took into account this unethical, this arrogant conduct, that's a violation of the principles of the rule of law, principles of the judicial proceedings management. So I thought that the judge did violate ethics. But as the Bangalore principles of judicial conduct says, that violation of ethical provisions on its own cannot entail the responsibility of the judge.
Can you tell the Commission, please, what your experience is in conducting investigations such as those that would be conducted by disciplinary inspectors?
The matter is that the assistant of the judge works with the case materials that are provided by the parties. All the evidence are provided by the party. In the criminal proceedings, it is provided by the prosecution party and the defense party. In the civil proceeding, they are provided by the respondent and claimant. So my experience as the assistant is to work with the materials provided by the parties and analysis of the provided materials. But I understand that while I hope being a disciplinary inspector, I will have powers to send different requests, to public authorities, local self-governance bodies, summon witnesses, that is, to commit an entire range of actions aimed at collecting evidence.
What is your familiarity with judicial ethics?
To the extent to which I worked with judges, I saw in practice conduct of judges. To the extent how I'm theoretically ready, I know which documents regulate the issue of ethical conduct of a judge.
And what documents are those?
Adopted Code of Judicial Conduct of a Judge, adopted unified requirements to judicial candidates. This is quite an extensive document that clearly describes what is included into ethical conduct of a judge. These are Bangalore principles of judicial conduct.
Thank you for your responses. I have additional questions, but I'm going to pass to my colleague at this time. Yakuyu.
Good afternoon. My first question is whether you can tell us what situations have you noticed in your workplace, in the company and in the court, what that would fall into the category of applying ethical principles in practice. I mean some serious cases, because as I'm studying the subject, the integrity in business theory is sometimes much more conceptualized and developed than the integrity in legal professions. So I'm aware of the importance of integrity issues in business. And since you worked for such an important company, I believe you might have noticed some issues which fall into the category of ethics or integrity issues. So whether you can name some from the business and some from the court practice. Thank you.
Thank you for your question. That's an interesting question. And in fact, in the company where I work, this business ethics is very highly developed. And we have lots of internal documents adopted that regulate issues of ethics and protection of information, ethical conduct, since we are the essential infrastructure object. So basically, all information is sensitive and protected, and I cannot talk about it. But I can say that indeed, it is well regulated, well governed when we are talking about all issues related to ethical conduct of a employee. And besides, as I have mentioned, we communicate with representatives of international financial organizations, and that also requires a high level of preparation, high level of communication skills. That's why, yes, in business, issues of ethics are really important. But in the court as well, I've already answered the question that is regulated by regulations.
That it's regulated, but even if I completely understand the sensitivity of the matter, I'm not asking about specific cases or details or names or sums of money, but types of issues which have this potential or essence which concerns ethics. What did you notice?
During the period of my work, during these 2 years, we have never had any instances of violation of ethical norms. We had no investigations, as far as I know, regarding that matter. We have not had any situation that would result in the necessity to conduct such an investigations.
If we don't speak about your company, Hydroenergo, but in business world, what ethical issues can happen in the business world which you consider interesting and serious and are willing to share with us?
On the one hand, the business world is built based on the arrangement between the parties. All agreements are concluded in writing, notarized, certified, and binding. That's why the violation of some ethical norms, it's difficult to imagine that, because everything is agreed upon. In case of a violation of conditions and terms of the contract or agreement, that entails responsibility, that entails possible claim to the court in order to protect the violated right. So that's why it is very difficult for me to apply these issues of ethical provisions to the business world purely theoretically.
The ethical principles, the integrity one, does corruption happen in business, in your view, or not?
I know that people talk about Ukraine as the country with a high level of corruption. Luckily, I have not encountered that. Maybe yes, maybe no. While working in my positions, while performing my duties, while performing all of my delegated functions, I have not faced corruption or violation of ethical norms.
That was not my question. I didn't ask whether you have encountered corruption, but whether you can imagine that corruption will be present in business world.
I will answer this question as follows. I have a very critical attitude towards all notifications and messages in the mass media, because right now one of the types of the war is information war, among other things. And that is a very powerful tool that is being used by competitors against each other. So I believe it is very important to have information hygiene and to thoroughly analyze all the content, including news, that I'm consuming. I'm trying for myself to filter it out. I follow official Telegram channels of official public bodies, and I understand that if there is information about corruption, about a huge scandal, then someone needs it for sure. And I understand that it is not an accident that there appears information in the information space. And I think it should be analyzed, and we need to think about that thoroughly. Thank you.
My second question follows up on my colleague Olha's question, why in Ukraine disciplinary cases are not only accessible to public but also broadcasted online. And you already responded that maybe one of the reasons is so the civil society organizations have access to that information and may have some level of control of what is going on. Is that the essence of your answer?
Yes, correctly, and not only control, but also increase of self-awareness, self-education in the context of activities of justice bodies, yes.
Top question is, why do you think this happened in Ukraine? What prompted this level of transparency and openness specifically in Ukraine?
I believe that this transparency and openness emerged thanks or due to the willingness of Ukraine to join the EU, to perform its commitments under Ukraine Facility Program, and maybe in order to fulfill requirements and conditions of this program, there have been created transparent proceedings regarding disciplinary considerations against judges.
Because I don't know if there is any EU country where disciplinary cases would be broadcasted online. So I can't imagine that EU would force Ukraine in order to be accepted, to broadcast, to do something what in the western part of Europe, or even in my country in eastern part, which is in many ways similar to the situation in Ukraine. We don't have that. So why do you think would this be related to EU accession and commitments? Maybe may there be some other reason for that? In your view, I don't know the answer, but I would like to hear what do you think?
The only thoughts which come to my mind that's transparency, increasing the level of awareness regarding the conditions, the status of the justice.
Okay, thank you. Did you have a chance to watch some of the interviews yesterday or listen to the questions we asked or not?
Yes, I had this opportunity.
So you might already hear this question, which I will ask. In your view, what is the role of a judge? What is the essence of the role of a judge in society?
I think that a judge, as a representative of one of the three branches of power in the country, has a very important role, mission, education to protect those rights of citizens which were not defined, not recognized, not fulfilled before.
And if we take this ideal and we take the last 15 years of Ukrainian history, were there occasions where judges were those who betrayed this role and did not even try to reach this ideal? Or what cases would you mention that may qualify to be in this category, if you understand?
Each time I'm recalling in my memory those judges who adopted decisions on Maidan, so Maidan judges, when Ukraine was fighting for its right to access the European Union, that maybe yes, such judges.
And did Ukraine deal with its past in a way that you think it's satisfactory or not? In this, specifically in this period of time of very difficult societal development around the Revolution of Dignity and the corruption scandals which were revealed later.
I think that yes. I think that Ukraine has handled it. I think that the level of the legal awareness is much higher. I mean, the level of legal awareness of our citizens, of our judges. That I think that yes, Ukraine as a country has handled this problem.
Okay.
Do you have any other questions in this part? Okay, so then we can move to the part on integrity questions. And indeed, there was a number of questions regarding some asset declarations and purchase of vehicles and ownership of the apartments. And you provided extensive explanations and additional documents. So just maybe a few moments to discuss. So one of the questions was about your relationship with the owner of the apartments that you used to live. One is in city of Briukovici, and then in your declaration from 2024, it was indicated that you had a right for free use of apartment in Kiev. And you explained that the owner of these apartments is the stepfather of your husband. That is right, yes? So this is the ground for this use of the apartments. Okay, then there was a question about the value of your vehicle, Nissan Rogue, that in your declaration the value was indicated twice bigger than it was in state register of vehicles, and you explained that it was due to some technical reasons that this kind of a technical mistake appeared in this register. So you submitted additional documents, an agreement of the purchase of the car, and it was corrected. So these answers satisfied us. And also this year in August, your husband acquired an apartment in Kiev, which is the value, let me see, the value is 2,500,000 hryvnias. So the question was the source of income for the purchase of this apartment, and you explained, but could you please just explain this situation, the source of income for the purchase of this really considerable real estate? Thank you.
Так, дякую, звичайно.
Yes, of course, I will explain. So, as a family, so we didn't have our property in Kiev. So we realized that we're going to live here, and our son has been enrolled in the first year of school, and there was an issue on the table regarding housing. We decided to take a mortgage and to purchase an apartment which is located on the left bank of the river. And it was quite a good apartment when repairs will be done there. The funds for first installment were gifted to us by mother of my husband. I provided the commission with documents. His mother and his stepfather were private entrepreneurs. They carried out entrepreneurship activities, and that's why they had and they have a financial capacity to help us, to support us, and those funds of my mother-in-law, those funds were used by us for was the first installment in this mortgage agreement. And as my husband has a good salary and I have a good salary now, we are paying off this mortgage created by ourselves, and each month we pay around 25,000. So this is a source of funds for us. So this is a gift. His mother gifted those funds, and that's a notarized deed of gift. And the source of funds for his mother, that's entrepreneurship activities.
I think it explains the source of the income for this purchase. And also there was a question that in this year as well, your husband acquired the ownership of the vehicle of Audi A6. And the value of this car is about $30,000 or more. So there was a question on what income it was purchased and what was real value. And do I understand correctly from the explanations and additional documents provided that this car was purchased in auction, and it was like after some accident? Is it correct? And the value was not that this is indicated, or not?
На аукціоні
So Honda was purchased at the auction. So Honda was purchased at the auction. Now, Audi S6 is owned by me, and the original funds, I will explain it to you. So we sold Nissan Rogue vehicle. I added up, I provided you with our income certificates issued by tax inspection and salary certificates issued by my employer, showing and corroborating that we had such funds to purchase it. So this vehicle is registered on my name, and we and my husband and I use this vehicle.
Thank you. Yes, and there were some questions about the declarations from 2022 about the income, but you explained this, so I do not have any additional questions with regard to financial integrity. No questions. Okay, so that's it from our side. We are just on time, finally. And so thank you very much for your answers and for your provided documents and additional explanations. And now it's time for your final remarks if you want to do so. So please, the floor is yours.
Dear Commission members, I'm so thankful to you for your time, for giving me this opportunity to participate in this competition, to have a floor in front of you. I so hope that indeed I managed to prove my compliance with this position at this interview. And I would like to say that in case if I win at this competition, I will do my best to work responsibly, in a qualitative manner, in a timely manner, and to contribute to the strengthening of justice. Thank you so much. Thank you. Thank you.
Results will be announced tomorrow in the morning. So thank you very much and good luck.